Who do we have next?
We can go to position number 4, Mr. Black. Michael Black.
Okay. Who's representing Mr. Black this morning?
Mr. Ty. She's right here, Your Honor.
Can we put one up, please?
You can keep that.
Okay. Sorry, I just need one.
Okay, just let me know when you're ready, Mr. Ty.
Okay. Yes, Your Honor, this is going to be a not guilty plea and a bond argument.
Okay, are you going to waive arraignment or would you like me to arraign him?
I'll waive arraignment.
Okay, file the waiver. Good morning, Mr. Black. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see. What's his current bond?
His current bond is a $1,000 good bond, and it was signed by you on July 15th, 2024.
Okay. And who do we have on from pretrial this morning? Oh, Ms. Tyson, good morning.
Yes, good morning, Your Honor.
May I get Mr. Black's history, please?
Yes, one moment. Now, it looks like Mr. Black is a multi-state offender. He has he has one arrest cycle out of Georgia, which is that's on the calendar. He has one arrest cycle out of California from 2021. Let's see, for purchase, possession, sale, narcotics, or controlled substances. And DUI, there's no disposition listed on the GCIC for that case. The arrest date on it is August 13th of 2021. He has one arrest cycle out of Texas from June 21st of 2024 for a liquor violation. No disposition listed on GCIC for that case either. He has two cycles out of Florida. First cycle being September 2nd of 2023 for trespassing and occupied structure. Let's see, it says other theft. Let's see. Disposition notes on the GCIC just states that his adjudication withheld October 23rd of 2023. No other information was provided. His last arrest in Florida was January 18th of 2024 for a failure to appear. One moment. It looks like he also has 5 cycles out of North Carolina beginning in 2015. His last arrest was April 3rd of 2023 for second-degree trespass. No dispositions listed for that case on the GCIC. And it looks like he has one cycle out of South Carolina from June 16th of 2019 for possession of other controlled substances in Schedule 1 to 5 first offense and unlawful carrying of a weapon. Disposition note on the GCIC states that it's a non-conviction. Nothing to add, Your Honor.
Thank you, Ms. McConkey.
Yes, Your Honor. The state believes that this bond is appropriate. The defendant, as you just heard from pretrial, has been arrested in multiple states. In this instance, he was accused of pushing the victim and also allegedly threatening him with a box cutter.
Did I make any notations? Do you have the bond there, Ms. McConkey? Did I make any notations on?
Yes, it was no further contact with the victim, Michael Cosby. Stay away from the information 2595 Park Street in East Point.
Okay, thank you. Yes, Mr. Ty.
Yes, Your Honor, my client is 28 years old. He is a resident of North Carolina, but he travels a lot for work and would have no problem returning for court here. It's a 4-hour drive from Georgia, Your Honor, and he doesn't drive anyway. He flies everywhere. I heard a lot of arrests, but not a lot of convictions. And Your Honor, this was at the first appearance hearing, this was a Riverside issue that was not brought up at first appearance to you. He was arrested, as you can see from the warrant, on these charges, and these charges only on July 12th at 12:30 a.m. or around 12:30 a.m. And he didn't have a hearing until the 15th at 2 p.m. So that would have been over 85 hours after his arrest. So he does wish to plead not guilty today. He firmly denies the allegations as stated in the warrant. At first appearance, the state had not contacted the complaining witness, and I would think they still haven't. Both of the numbers listed are not active. One is not even, it's for an apartment complex, not for the individual who is listed as the witness. And the complaining witness, also not a correct number. Again, he does deny the allegations. It was a Riverside issue at first appearance. So he's pleading not guilty, and I'm asking because it was a Riverside issue at that time, and he's been held for 18 days since then for a signature bond through pretrial services.
Okay. Given that the recommendation is a time served recommendation and that he's been in custody since I last saw him, I'll convert the good bond to a $5,000 signature bond through pretrial level 1-day anger awareness, no further contact with Michael Cosby, stay away from the Park Street address, and no drugs, alcohol, weapons while out on bond. Let me make sure that Mr. Cosby's not with us. Is Michael Cosby on the Zoom call with us this morning? Does not appear so. If you'll prepare that modification, Ms. Attai, we'll get it signed and entered.
Thank you, Your Honor.
Thank you.
You're welcome, sir. Good luck to you.
We can go to position numbers 9 and 10, Mr. Bernard Cooper.
And this is going to be a negotiated plea. And it's no.
I just need a minute, Your Honor.
Okay.
You want me to do that? Your Honor, I think I may need a minute to speak with him. If we can go to another.
Okay, and before you speak with him, Mr. Ty, we have had an opportunity to speak with the victim in this case, and she does want to stay away. She does not want the defendant to return to the residence. I do not think the original plea offer stated that there was going to be a stay away, but the victim would like a stay away. So that is now.
I think she spoke with Iman Cheney. I spoke with her last night, and that's not the case. She stated to me that, you know, very clearly that she doesn't want to stay away and was expecting, you know, if he's released, for him to come home, not to live there, but they're very close. They've been best friends for 16 years. She stated that she doesn't want to press charges, and she told me that she couldn't join Zoom because of, challenges.
She's on.
Oh, she's on Zoom? Oh, okay.
Okay,
So
well then we can
that's
just,
not the case.
because it was my understanding that he can come home, shower, get his belongings, but he needs to leave. So
So
because
that's
she
not a
wants him
stay
to leave
away.
and not, well, because she doesn't want him to live there and she wants him to leave and not be there, the state's recommendation would be a stay away. He has a one-time police escort to go pick up his things, and then he needs to stay away from the residence. But of course, if she is on the Zoom, we can speak to her directly.
Okay, before we move on, is this Mr. Cooper?
Yes, ma'am. Yes, sir, it is. I'm sorry.
Okay, so for Mr. Cooper, on my notes, I said that I have a no further violent contact with a Larry Nixon. I don't have anyone else except for Larry Nixon on the recommendation from the state.
Yes, that is correct, Your Honor.
Okay, and so, and is Larry Nixon a man?
I think she is on here as Larita Nix.
Yeah, I believe that she
Raising her hand.
identifies as a woman.
Oh, okay, all right, so thank you. What do you all want me to do with Mr. Cooper at the present time? Do you need some more time, Mr. Ty? Do you want me to address Ms. Nixon?
Yes, Your Honor, while she's on.
Okay. Good morning, Ms. Nixon. If you'd like to address the court this morning, I'll need for you to unmute yourself.
Judge, there's a feedback on her thing. If she can turn her volume down or something, there's a feedback.
Volume down for me.
No,
Okay, I can hear you. I can hear you now, ma'am. If you raise your right hand, for me, do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes, sir.
Okay, you can place your hand down. What would you like to tell the court this morning?
I'd like to tell the court, I don't know, my neighbor pressed, called the police on Bernard. Me and Bernard been together 15 years. He my best friend. But that day, it was just a lot of confusion. Other people got into it. I had filed for eviction. I'm happy after he left the home, we good. We can have a good conversation and things. But when they arrested him right before his birthday, we had planned a party for him at our daughter's house. I don't see nothing bad happen to Bernard because I love him, but I'm not in love with him no more. We friends. Okay? I don't want to see nothing bad happen to him. And I did tell the advocate that he can come to the house, take a bath, change his clothes, and leave. I did say that.
Okay, and this incident alleged will happen back in September of 2023. Have you all been around each other since that time?
Yes, sir. We been, like all I wanted him was to get out of my house because he told me he wasn't going. But we've been in the acting and everything, because we got kids together.
You're not afraid of him? Did you hear my question, ma'am?
Huh?
You're not afraid of him?
No, I'm not afraid of Bernard, no. Because
Okay.
listen, I had a stroke in 2022. Bernard was there to help me through my stroke. He been through all of that. I had to learn how to walk and talk again. And he helped me through all of that. That's why only problem is when Bernard get away and do his thing, I don't like that. You know what I'm saying? I don't like that when he come back home and be fussing and arguing because I know what he been and done. But other than that, me and Bernard is good.
All right. Thank you for being here, ma'am.
Thank you. I appreciate y'all.
You're welcome. How would you like to proceed, Mr. Ty?
Your Honor, okay, Your Honor, it's going to be a non-negotiated plea. He does wish to plead guilty, but I am asking for a time served. It's 45 days. I think credit for time served 21 days, so that leaves a day and a half. So I would like to ask for it to be time served and the balance suspended. Of course, no violent contact with Ms. Nixon. And I would object to the FVIP and the 60 hours of community service. He has been residentially challenged and he will be when he gets out, but I believe that he gets a social security check. It's $943 a month. The FVIP is 80% of his monthly fixed income, at least. It could be, even more than that, 90%. So I don't think he's in a position to pay for the FVIP or even do community service. He has a hard time even taking care of himself. And reporting to probation, I just don't think with you've heard from the complaining witness that she doesn't want to press charges. She's not afraid of him. She does want contact. The neighbor called the police. Of course, we want the FTA lifted, and that's what's holding him here now. So he's willing to plead guilty just to be able to get out of jail today.
Okay, well, with all that said, if he pleads guilty to battery family violence, I believe it's statutory that he does the FVIP. And if he is going to plead guilty to anything, I'll be reticent to give him a time served plea. I would consider making it not requiring him to do any more time in jail. But he is going to have to do some type of, he will be on probation and he is going to have to do some type of, given his situation, I would consider converting it to anger management. And yeah, I believe he can do the 60 hours of community service, but he will be doing something on probation. I'll just say that.
How many weeks of anger management?
12 weeks of anger management, 60 hours of community service. So the court would be inclined to give him a sentence of 12 months to serve 42 days, credit for time served, 21 days, bound probated, no further violent contact with Ms. Nixon, 12 months of anger management, 60 hours of community service, and no firearms.
Well, Your Honor,
The other option, Ms. Atai, is he missed a court date, is returning this to the division judge so that they can modify his bond if he would choose to have that done.
We can give them a second,
Yeah.
Your Honor,
Your Honor, I just need to speak with him.
and go to another
Okay.
case.
All right, we'll be back with Mr. Cooper.
Good morning, Judge Morrow. If we can do AC/DC,
Yes, good morning. Well, I hope you're well today. Thank you.
thank you. Hope you are as well. I do have a couple of announcements,
I'm
Judge
sorry.
Morrow.
Okay,
For AC/DC, positions 27 through 29, Miss Coletta Emily, she's waived her appearance. And also for positions 32 and 34, Miss Sneed LaShawn, she also waived her appearance.
She has not spoken.
so who's representing Miss Oulette 27 and 28?
That's going to be Miss Hoda.
Okay,
Judge, if I could interject just for, she's got all of the AC/DC cases, so she's speaking with the other client, and I'm the only other person here, so.
okay. Okay, Mr. White, good morning.
More.
So we'll
Also-
have,
Well, I do have two other cases here for Miss Brown. That's position number 5.
I believe what Mr. White is saying is that all the cases at ACDC are Miss Atai's cases, and she is
Okay.
not available right now.
She's not available. Okay.
So I'll make note of those announcements so I can let her know when she is available, and then we'll come back to you when we can. Okay,
Okay. Thank you,
right.
Judge.
All right. And let's go to Mr. White's cases, if we can.
We can go to position number 19 and 20, Mr. Hargrove.
And Judge, I just spoke with Mr. Hargrove. He's going to be entering a plea, negotiated plea today.
Okay, thank you. Good morning, Mr. Hargrove. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, sir. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, sir. Yes, Ms. McConkey.
Yes, Your Honor. For Mr. Hargrove, there are 10 different charges. So for count 1, cruelty, it is going to be 12 months served, 42 days, credit for time served, 21 days, balance probated, BARC, and reporting to the Animal Cruelty Registry, and the defendant may not own any animals in his household for 1 year. For count 2, cruelty, it is going to be the same, 12 months probation served, 42 days, credit for time served, 21 days, balance probated, BARC, and reporting to the Animal Cruelty Registry. Defendant may own no animals or have any animals in his household for 1 year. That is consecutive to count 1. For count 3, the failure to shelter, that is going to be 12 months concurrent with count 1. For count 4, the obstruction, that is going to be 12 months concurrent with count 1 and a $300 fine. For count 5, the dog at large, that is going to be 12 months concurrent with count 1. For count 6, cruelty, that is going to be 12 months, served 42 days, credit for time served 21 days, balance probated, BARC, and reporting to the Animal Cruelty Registry. He may not own any animals for 1 year, and that is consecutive to count 2. For count 7, the tethering, that is going to be 12 months concurrent with count 1 and a $250 fine. For count 8, the cruelty, that is going to be basically time served, balance probated, BARC, report to the Animal Cruelty Registry, no animals for 1 year. That is consecutive to count 6. For count 9, cruelty, time served.
I'm sorry. My offer sheet stops at count 7.
No, it goes all the way to count 10.
I understand that. There are 10 counts. I see that, but my offer stopped at count 7. So
I'm not sure why. It shouldn't stop at count 7. Let me take a look at the email that was sent out.
I've got the calendar printed out here.
I'll just say my calendar contains all of them, so we may need to give you the rest of them, Mr. White, so you can discuss them with your client.
And mine also contains all of them, and that's the email that I sent out.
Yes, mine as well. So,
Okay, so why don't we do this? Why don't we just go ahead and put them on the record, or if you can just make notes, Mr. White, and if you need to talk with Mr. Hargrove about it, then we'll give you that opportunity.
Okay.
Okay. So let's start at, so I guess we need to start at count 8 so that Mr. White can make notes if need be.
yes, okay.
Okay.
Count 8 was the cruelty. That was 12 months, served 42 days, credit for time served 21 days, balance probated, BARC, and reporting to the Animal Cruelty Registry. He cannot own any animals for 1 year. That is consecutive to count 6. Count 9, cruelty, 12 months, served 42 days, credit for time served 21 days, balance probated, BARC, report to the Animal Cruelty Registry. He cannot own any animals for 1 year. That is consecutive to count 8. Count 10, cruelty, 12 months, served 42 days, credit for time served 21 days, balance probated, BARC, no animals for a year, report to the Animal Cruelty Registry, and that is consecutive to count 9.
So just to be sure, you've got 6 years of probation?
That's what I wanted to clarify too, when she keeps saying consecutive. He's gonna be on probation for almost 8 to 9 years.
A couple of them were concurrent, but my final count was 6 years.
So the cruelties were consecutive, so that he would not own any animals for 6 years.
Right. So 6 years, so, okay. We're withdrawing our guilty plea, Judge, enter not guilty plea, and, we can, arraign him and have, we'll wait formal reading.
Okay,
He could go non-reporting after the first year, but no animals for 6 years.
Okay, Judge, we're okay with that.
okay. Anything further, Ms. McConkey?
Nothing further, Your Honor. And then, of course, the FTA would be no crossed.
Yes, anything further, Mr. White?
Nothing from us, Judge.
Okay. Mr. Hargrove, it's my understanding that in case 22 CR 0000359B, you wish to plead guilty to 5 counts of cruelty to animals, 1 count of cruelty to animals, failure to provide shelter, obstruction of an animal control officer, dog at large, and tethering. Is that correct?
You want to interview? That's what he's asking. Yes.
Okay, that's your understanding, Mr. Hargrove?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
Represented by counsel, are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Hargrove. After the first year, the probation will go to a non-reporting status. Good luck to you, sir.
Thank you, Judge.
Okay, I just want to make sure I got this clear, because I got to write this up. I'm sorry for interrupting, because that was kind of a lot. So you're saying that he's going to be on probation for a total of 6 years on all these charges, and then go non-reporting after the first year, and he has a $300 fine and a $250 fine. Is that correct?
Yes.
Who are you asking? Okay. That your intent, Ms. McConkey?
Yes, that is my intent, Your Honor.
And that's your understanding of the intent, Mr. White?
It is, Judge.
Okay, all right. Are you clear, Ms. Lewis?
Yes, I just need to make sure I have this correct so I can write it up properly. Thank you, Judge.
You're welcome. Thank you. All right. Good luck to you, Mr. Hargrove.
Next, we can go to position number 17, Ms. McGrath. Rodriguez.
Okay. This is a negotiated plea.
It is, Judge.
Good morning, Mr. Greer. I am Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me, please, Mr. Greer? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hands down. Ms. McConkey?
Yes, Your Honor. The recommendation is 12 months served, 30 days, credit for time served, 15 days, balance suspended, no further contact with Teresa Blackwell, stay away from the incident location, 1349 Kellenworth Drive, Southwest Atlanta.
White?
Nothing further, Judge.
Mr. Greer, it's my understanding that in case 24 CR 004803F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Represented by counsel, are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Greer. Good luck to you, sir.
Thank you, Judge.
You can have it. We can go back to, position number 9 and 10, Mr. Cooper.
Yes,
Your Honor,
Mr. Ty.
yes, he does wish to plead guilty, but the reason why I was asking for time served is because the recommendation from the state is 45 days, credit for time served 21 days, so that leaves 3 days, so,
I was gonna give him time served.
oh, okay, thank
I was
you, Your
just-
Honor.
But I was not gonna not allow it to have probation, but I was gonna give him the time served.
Okay, and then, Your Honor, I also want to ask for the 12 weeks of anger management and the 60 hours of community service, can his probation go non-reporting upon completion of those 2 requirements?
That's fine with the court.
Okay, thank you.
So what does he want to do this morning?
A guilty plea, Your Honor.
Okay, yes, Ms. McCarthy.
Yes, Your Honor. The state's recommendation stands as it was. He does have 47 arrest cycles. But, we will of course defer to the court.
Anything else that you'd like to put on the record, Ms. McCarthy?
Just that this incident did occur on September 18th, 2023. He did punch the victim, Larry Nixon, in the eye and also pushed her to the ground and allegedly punched her in the lip. She did have a bruise to her left eye and a scrape to her elbow. He was mad at her because the victim had picked him up early in the evening and he didn't have enough money to get a ride back to work. She offered him $10, which infuriated him even further. And that is why he proceeded to attack her. And that is why the state's recommendation was for 60 hours community service and FVIP and 45 days to serve.
Okay, Mr. Ty?
Your Honor, you heard from the complaining witness. He supported her through 3 strokes and recovery, and she states that they're best friends and that she did not call the police. She does not want to press charges, and that's all. He's pleading guilty today.
Okay, Mr. Cooper, it's my understanding that in case 23 CR 007256A, you wish to plead guilty to battery family violence. Is that correct?
Yes, it is, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Cooper. The court sentence is going to be 12 months to serve, 42 days, credit for time served, 21 days, balance probated, no further violent contact with Ms. Nixon, 12 months of 12 weeks of anger management, 60 hours of community service, no firearms. Once you complete the terms of the probation, it will go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation.
Thank you so much.
You're welcome, Mr. Cooper. Good luck to you, sir.
Yes, sir. Thank you.
You're welcome. Mr. Ty, while I still have you right there, there was an announcement made on positions 27 and 28. Ms. Ouellette, that she would not, that she was waiving her appearance today. Are we returning that case to the division judge?
Yes, Your Honor. I did speak with Ms. Ouellette, and I'll file a waiver of presence and arraignment, and that's a not guilty plea. And also position 32 and 33 and 34, LaShawn Sneed. It's also a waiver of presence and waiver of arraignment and not guilty plea.
Okay. So, Francois, we got that completed. And it's my understanding that Mr. Ty, the remainder of the cases at ACDC are yours. So if we can go ahead and take those so that I can release the ACDC.
Okay.
Is that what you're requesting?
Yes.
Is that
Thank you,
fine with you?
Judge.
Okay.
This is gonna be position number 5, Ms. Brown.
This is going to be a negotiated plea.
Let me see. Your Honor, it's a non-negotiated plea.
Okay. Good morning, Ms. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You have to speak up for me.
Yes.
Okay, thank you, ma'am. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down, ma'am. Let's see. May I get Ms. Tyson? May I get her history, please?
Yes, Your Honor. We have 13 arrest cycles beginning in 2009. Her last arrest looks like June 22nd of 2024 in Atlanta for criminal damage to property in the second degree. There's no disposition listed in the GCIC for that case. Looks like she has a misdemeanor conviction that she took a NOLO plea on for marijuana possession less than 1 ounce, December 4th of 2023. We have a possible pending case. It looks like, I'm not sure if this is the same. It's a simple battery in public transit vehicle or station and a criminal trespass. The arrest date on that case was October 19th of 2023. We have another misdemeanor conviction for criminal trespass from June of 2019. We have a misdemeanor conviction for simple battery. Let's see. All right, let's see. Looks like 4 counts of simple battery family violence out of Fulton County from August of 2017. And 1 violation of probation. Nothing to add, Your Honor.
I'm sorry, what was she on probation for?
Let's see, that was from, give me 1 second. That was from 2018. I'm not sure. It's not giving me the underlying charge, Your Honor.
All
Wait,
right,
let's see. It looks like it was that simple battery case with the 4 counts of simple battery family violence.
okay. Thank you. Ms. McConkey?
Yes, Your Honor. This incident occurred July 15th, 2024. The defendant is accused of slapping Curtis Motley, who was a security guard at Express Food and Pharmacy. The defendant had previously been given a criminal trespass from the location on January 19th, 2024. And apparently that is what she was arguing with the victim about when she slapped him. The incident was caught on security footage. The defendant did return to the store the following day, July 16th, and that is when the victim called the police. The state's recommendation, given her history, which does of course include that 2017 simple battery conviction and 2023 simple battery arrest. I do also see that she has a 2017 simple battery that was null prost. The state's recommendation for count 1 is 12 months served 45 days, credit for time served 14 days. Balance probated, no further contact with the victim, Curtis Motley. Stay away from that Express Food and Pharmacy located at 50 Upper Alabama Street. 12 weeks anger management, 40 hours community service, no firearms. For count 2, it is going to be 12 months concurrent with count 1. And I would ask the court to sound for the victim, Mr. Curtis Motley.
Mr. Motley is on the line and wishes to address the court. Now is your opportunity to do so. Mr. Ty?
Yes, Your Honor. The plea is non-negotiated. Not as to the time served. She actually has, no bond on another case where she has a hearing coming up August 28th. So, the 45 days with credit for time served, 14 days, is fine. But I am asking again, for the elimination of the 12-week anger management and at the most 40 hours of community service. She's 32 years old. She's lived in Georgia all her life. She is a high school graduate, completed 2 years of college. She was employed at America's Mart and hopes to still have that job when she's released. She does have family support in Atlanta, her mother and cousin, but she has been residentially challenged. But she states that she's working with Pat, and I reached out to Pat, and I see that we had a Pat representative on the line. So I would just, and she does want to continue to work with Pat, so I would ask, instead of 12 weeks anger management, again, which she can't afford, that she does the 40 hours of community service, but, I mean, at the most, a 1 or 2 day anger awareness, and she'll continue to be working with Pat.
Given the defendant's history, the state believes 12 weeks of anger management is more than appropriate.
Your Honor, it's a simple battery from 2017. That's 7 years ago.
And she does have a 2023 arrest for simple battery in a public transit vehicle or station.
An arrest.
Okay, I'm inclined to accept the state's recommendation, given the history and what I've heard as far as these allegations go. If she wants more time to do the community service, I'm happy to make it to give her more time on probation, to make it consecutive as opposed to concurrent, to give her 2 years to get it done.
I think she's saying that I think I may need to speak with her.
Okay, I mean, if the issue is that she needs more time, I'm happy to give her more time.
Your Honor, if I may
I'll
speak,
take it.
I'm Victoria, her care navigator. I'm on the line
Thank you.
with Pat.
Okay. Oh, yes, yes, Ms. Hull. Can you go ahead and unmute yourself?
Hi, I've been working with Ms. Brown, and she is working on some goals. And we are working on her housing as well.
Okay. I appreciate that. Thank you, Ms. Hall. Do you need to speak with her, Mr. Ty?
Yes, Your Honor, because I know that she was just stating that she can report to probation, but she does not have funds to pay for 12 weeks of anger management. I mean, there has to be something else.
I'm happy to give her 2 years I mean, hopefully she can get on her feet in the next 2 years. And if she needs more time so that she's not going to violate her probation, and then it'll go and then I'll just have it terminate once she completes everything that she has to do. So I'll give her some extra time to get it done, and I'll have it terminate as soon as she does it, if the issue is that she needs more time. But given what I've heard, I will be accepting the recommendation.
Well, I mean, Your Honor, even if she has 2 years to complete it, it's, $45 or $50 a month to be on probation for 2 years for somebody who is homeless and is going to be working with PAD to even get housing. It just doesn't make sense.
Okay, well, I'm not accepting the recommendation at all. It makes sense to the court. Apparently it makes sense to Ms. McConkey. I'm just not going to let someone do what she's alleged to do and not have to pay any consequences for it, except for spend some time in jail. I believe that she needs anger management. I believe that she can do 40 hours of community service. I'm giving her extra time to do it. I don't know what more you want me to do. So you all decide to let me know.
Ms. Brown, we can also just plead not guilty today and then send you probably, I mean, within the time that you're going to be here anyway, you'll.
Not guilty.
Okay.
Okay. Are you going to file a waiver of arraignment, or would you like me to arraign her, Mr. Ty?
I'll file a waiver.
Okay. Ms. Brown, your case will be returned to the division judge. You'll get notification of your next hearing date, ma'am. Good luck to you. Who do we have next?
Next, we could go to position number 21, Mr. Dion Henderson.
Do we want to finish up with AC/DC first?
Hold on.
My next one, Judge, is gonna be position number 52, Ms. Worthings.
Mr. Ty has stepped away for a second.
Can we go back to position 20? Never mind. Can we go back to position 21, Judge? Ms. Atai's been called away for a second.
Okay, that's fine.
Henderson.
And Judge, Mr. Henderson was on our calendar last week and we entered a not guilty and waived arraignment. And I know the case was reset for today, and I just don't remember exactly why Your Honor did that.
I think that we were gonna give you the opportunity to speak with him. You hold on a second, let me pull my calendar for last week.
Okay.
What are you doing, sir? Have a seat.
See what time it is. 10 till 10.
No, no.
I don't have him on the calendar from last week.
Your Honor, which case is this?
This is Dion Henderson, position 21. He's not on the regular calendar.
He was on the regular count on July the 23rd, Judge. In his
Oh,
recent-
July 23rd. Okay.
Marcia. Remember you said you were gonna take this. You wanna do that right now? Norman, go sit in the blue chair back there.
I think your issue was the time that he was going to be in custody, Mr. White.
Yeah, I mean,
Yeah.
that's probably part of the reason we entered a not guilty plea. So I'm just, I don't believe I asked for it to be reset to the day.
Okay, so if Ms. Falk, do you have any
Yeah.
present recollection or make any notes?
My notes say that Mr. White requested a bond modification. The bond modification was then denied by the court, and at that point, it was requested to be reset to today's SAP.
Okay.
I don't know
So-
if that would revisit the recommendation or
And I did have that it was $1,000 good bond that that he currently has.
that is correct, Your Honor.
Okay, well,
Judge, Mr. Henderson may actually want to enter a plea now, if you give me a couple of minutes to speak with him.
Okay. All right, just let me know.
And Your Honor, he also, just to let the court know, he also has a holdout of Newton County.
And he's aware of that.
Thank you. All right, just let me know when you ready to go
Mr. Ty's not
forward.
back yet, Judge, so give me just 1 second.
Okay.
You know, we're good with the plea except for the stay away. That's his home. That address. And Miss Nakobe Merriweather does not live at that address. So we have no problem with the no further contact with Miss Merriweather, but the stay away at 210 Auburn Avenue, apartment 203, that's his place.
I'll give him
That is his sister's residence, and Miss Nakobe is his sister's girlfriend.
He's on the lease from what I understand. She's not.
Okay, so what I can do is I can give him a one-time escort to go back. If she's living there, of course, he can't be there and he can retrieve his belongings. If she's not living there, then he can necessarily be there. Would that work, Mr. White?
Yes, Judge, we're agreeable with that.
Okay. All right, so I'm sorry to be talking about you without addressing you, Mr. Henderson. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation is 12 months to serve 60 days, credit for time served 23 days, balance probated, no further contact with Nakobe Merriweather, stay away from the incident location, 210 Auburn Avenue, Atlanta, 12 weeks anger management, 40 hours community service, no firearms.
Anything further, Mr. White?
We have nothing further, Judge. Just ask the probation go non-reporting once he completes all of his requirements.
And I would just ask the court to sound for the victim just in case she is on the Zoom.
Okay. If Ms. Nakobe Merriweather is with us this morning and would like to address the court, now is your opportunity to do so. Okay, Mr. Henderson, it's my understanding that in case 24 CR 004474Y, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Henderson. You can go back to that location on one occasion with law enforcement. If Ms. Merriweather does not reside there, you can reside there. If she does, then you will have to get your belongings and find somewhere else to reside. When you complete the terms of the probation, it'll go to a non-reporting status. Good luck to you, sir.
Your Honor, if we can go to probation, I have one that has a private attorney for probation.
Okay.
I need to fight the same.
Probation number 3, Mr. Roger.
It's all. You gotta do that back. All right.
Okay, and let's see, who's representing Mr. Rogers?
My wife didn't tell me his last name.
That's me, Judge.
Oh, yes, good morning, Mr. Springer. Good morning, Mr. Rogers. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video? And courtroom 2, you have to unmute there. Thank you.
Yes, sir.
Thank you. Good morning, Officer Allen.
Good morning, Your Honor. The defendant was sentenced to probation for the charge of DUI less safe. He was ordered to serve 12 months of probation, pay a probation fine as well as supervision fees, complete 40 hours of community service, substance abuse evaluation, as well as risk reduction. Your Honor, he has failed to pay the fine amount of $862.50. Your Honor, he has failed to pay the probation supervision fees, complete the risk reduction, as well as the substance abuse evaluation and the 40 hours of community service. Unfortunately, Your Honor, it's only 14 days remaining on his case. He was booked at Fulton County Jail on July the 22nd, 2024. Your Honor, probation recommends that this case be time served.
Mr. Springer?
Judge, we don't have any objection to the time served. I've had a long conversation with Mr. Rogers. He was going through some things back in 2019. He was struggling with a period of homelessness and kind of fell off the wagon, but he's been living his life well for the last 4 years. His wife is on the call. They've got 3 children together. He works as a mechanic, so the day he's out, he will be back at work the next day. But we've had a long conversation about how problems don't go away if you ignore them. So he's known for the last 4 or 5 years that this is hanging over his head. But he has now basically served almost the balance of the amount of time that's left on his probation. So if you time serve this today, I don't think you'll ever see him in your courtroom again.
Okay, time served. Good luck to you, Mr. Rogers.
And Your Honor, can we just put on the record, Mr. Rogers, just please be patient with the Fulton County Jail. I will submit the paperwork once it's signed, so you don't have to reach out to your attorney. Hopefully you will be released sometime today or tomorrow.
Thank you. All right.
Thank you, Judge.
All right, have a good rest of your day, Mr. Springer.
You too, Judge.
Thank you. Who do we have next?
Probation 1 and 2, Mr. Blockton.
Good morning, Mr. Bloxton. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Officer Allen.
Your Honor, the defendant was charged with simple assault. He was ordered to serve 12 months probation, stay away from the location, no contact with the victim, and complete 6 weeks of anger management classes. Unfortunately, he has failed to provide our office with completion of the anger management course. He's been in custody since July the 22nd, 2024. It's 248 days remaining on his case. At this time, probation recommends for him to be allowed to continue on probation to complete the anger management course.
Mr. White?
Lost my child when I was here last time, so they so. He's good to continue on probation. There were some issues along the way, but he's good to continue on probation.
Okay, Mr. Bloxton, I know people go through things from time to time. If you let people know that you're going through something, they will work with you many times. Stay in touch with probation. If you're going through something, they'll be able to report that to me. If you just fall off and not report, and no one knows what happens, then you end up back here. So I'm going to give you the opportunity to make this right, and just go ahead and knock it out so that you can put this behind you. Okay.
Yes, sir.
All right. I'll reinstate you, Mr. Bloxton. Good luck to you, sir.
Thank you, Judge.
Your Honor, that concludes my business. May I be excused?
Yes, Officer Allen. Thank you. We'll see you.
Thank you.
Are we ready for position number 52, Ms. Worthens? Is Ms. Hoda available?
No, she's currently talking to a client.
Say it again, Mr. Ty.
Talking to one of her clients.
I'll be with you as soon as I can.
Thank you.
We can
We can go to Ms. McLeod's, one of Ms. McLeod's clients on the add-on calendar, position 1 and 2.
Good morning, Ms. McLeod.
Good morning, Your Honor.
What are we doing with Mr. Carter this morning?
For Mr. Carter, Your Honor, we will be asking for bond.
Okay.
If his bond can be modified, yes. He's going to enter a not guilty plea and see if his bond can be modified.
Are you going to file a waiver, or do you need for me to arrange?
I will file a waiver, Your Honor.
Okay. I take it that my policy, Ms. McLeod, is that if he misses another judge's calendar, and they issue a bond, that I return it to them for modification. I take it that he missed a court date, Ms. Falk?
Yes, Your Honor. Just looking at this, it appears his bond was forfeited on September 13th of, his bond judgment forfeiture calendar, Your Honor, is September 13th of this year. It looks like, trying to see where exactly he missed court. Let me take a look at his, actual bench warrant. And so he currently has a $4,000 surety bond on this failure to appear. It was signed by Judge Porter on April 23rd of 2024, which means the court date that he missed, according to our information, is, yes, his bond was ordered forfeited on April 23rd of 2024. But I'm not clear what hearing exactly that was. It's not showing me what the actual appearance was, but he failed to appear on that date and a bench warrant was issued for him at that time. It looks like it may have been I'm looking at the criminal calendar notice. Okay, so it was a status conference calendar on that date at 9:30 a.m.
Ms. McLeod?
Yes, Your Honor. My client did not apparently get notice on this, Your Honor. I think I saw a return.
Yeah.
A return in the file where the mailing was returned.
What address did it have on it, Ms. McLeod? Was it an improper address?
I can't say that the address was necessarily improper, Your Honor. It just said return to sender, so I don't.
Right, it said return to sender and that it was vacant and unable to forward. And that was 2 notices that were returned, one on February 2nd, 2024, one on May 15th, 2024. It also appears that
one of his first name is Green.
Right. So there were 2 return to senders, Your Honor, and it doesn't appear that there's a defect with the address.
And
what is the address?
The address that we have, Your Honor, is 1944 Piedmont Circle, 153 in Atlanta, Georgia.
And Your Honor, based on what my client tells me, this was kind of a shared facility. He's challenged in terms of accommodation, and he was living in a shared facility. And I think it could be that he did not have access after this incident, because my understanding is that the alleged victim also lived there. So it wasn't like they shared a home, it was a shared, like a home, you know, a group
That's
home.
the stay away address is not that address, Ms. McLeod. It's 855 Oak Street, which is the address he was told to stay away from. That is not the same address as the address that he gave for his service of mail.
I understand, but I was saying he is challenged in terms of accommodation, and that could be the issue why his the mail went astray.
Right, but
have
you
a
also
stable-
said that he was told to stay away from that address, but that is not the stay away address. That is not the address where the victim lived or that he was ordered to
Okay,
stay away from.
I apologize. I thought that was the address.
Does he have a stable address, Ms. McLeod?
Not at the moment, Your Honor.
I'm gonna follow my policy. I'm gonna return it to Judge Porter's courtroom so that she can make a determination as to if she would like to modify the bond or not. So he'll get his another hearing notice from Judge Porter's court. All right. Good luck to you, Mr. Carter.
Thank you, Your Honor.
Ms. McLeod also have two clients at Marietta Annex on the
Yes.
add-on calendar, positions 3 through 4 and 5 through 9.
That is correct.
And Your Honor, in the court, I did just, and I apologize, I did overlook the add-on calendar. I did update it and send it out about 20 minutes ago to everyone. So you should have it in your emails.
The person that's in front of the camera at Marietta Annex is position 5 through 9, Mr. Quantavious Green.
And what are we doing with Mr. Green this morning, Ms. McLeod?
This is going to be a negotiated plea, Your Honor, resolving all of the cases.
Very good. Marietta Annex, can you unmute for me? Yes, good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can place your hand down. Thank you, Mr. Green. Ms. Falk?
Yes, Your Honor. Starting with position 5 on the calendar, the state's recommendation to the 1 count of battery is 12 months to serve, credit for time served 119 days from March 26, 2023 to July 7th of 2023. Position number 6, 2 counts of simple battery. The state's recommendation is 12 months probation consecutive to position number 5, balance probated, no further contact with Natasha King, Joe Stodgehill, and Michael Fleming, as well as Patrice King and Dawn Harris. 12 weeks of anger management, ADET, no firearms. Count 2 is 12 months concurrent with count 1. Position number 7, the battery, state's recommendation is 12 months consecutive with position number 6. Battery balance probated, no further contact with the same individuals, Natasha King, Joe Stodgehill, Michael Fleming, Patrice King, and Dawn Harris, and no firearms. Count 8, position number 8, simple battery, 12 months concurrent with all other cases listed above. This is a global recommendation. The total is 36 months served, 12 months, credit for time served, 119 days, as well as stay away from no further contact with all of the individuals listed, no firearms. We would like to sound for Natasha King, Joe Stodgehill, Michael Fleming, Patrice King, or Dawn Harris if they would like to speak at this time. And the state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. I did actually leave out one additional case, which was position 8. I covered position 8. So that's it for the state. Thank you.
If any of those individuals are on the line and wish to address the court, now is your opportunity to do so. Ms. McLeod?
Yes, Your Honor. I just wanted to, how much time does he have to spend more in jail?
That would be, he received credit for 119 days. Let me just make sure that was properly updated.
Okay, because I was under the impression that he had been in jail for pretty much for a year. That's what he told me.
That is, let me just double check. That is not what I have, and that is not what is on the recommendation that I sent.
Well, based on your recommendation, how much more time does he have to spend? Because I want him to be clear.
I am showing that he spent 114 days, and there is another 28 days that he has spent. well, hold on. Is that this battery or is that the previous battery? Right. So he had spent 114 days on his battery and then another 4 days on his battery for a total of 118 days. I think his arrest date was the day before what's listed on the booking, which is how he got 119 days credit for time served.
Okay. And that's so what does that
With
mean?
2 for 1, that would be, he would have served at this point 238.
So
for
how
the
much
year.
does it mean that, I'm sorry, I'm really bad with the calculations, that's why I'm asking.
As am I. So I will let the jail do those calculations, since 2 for 1 credit is not guaranteed by the jail. It normally is, but I don't want to.
I think my client was under the impression that he was going to get out today.
Right. I'm not sure how he would be under that impression, because the state's recommendation clearly stated he was only getting 119 days credit for time served toward a 12-month jail sentence. So I'm not sure how that got miscommunicated, but that was the state's recommendation.
Okay, I need to make sure he was okay with that.
Okay, absolutely.
So I
Would you
to speak.
Or I can place you into a breakout room, Ms. McLeod.
Yes, that would be great if I could go in a breakout room with him.
In my calculations, and it might not be right, but it would be 64 additional days.
For additional, I need to speak to him.
Okay. All right, so if we can place Ms. McLeod and Marietta Annex into a breakout room, please.
And Ms. McLeod, just letting you know before you do go into a breakout with him, the defendant currently is also on a $20,000 surety bond for a 23 CP 217230 case. So unless he was planning on paying that today, he wasn't going anywhere because of his felony case.
I understand, but I just need to make sure that he's okay with that.
Completely understand.
Okay, so if we can go ahead and place him into the breakout room, please. And let's go back to Ms. Ty's case with ACDC. Who do we have at ACDC?
Thank you, Judge. This is position number 52, Ms. Worthens.
Okay, and this is going to be a negotiated plea.
Your Honor, sorry, it's a non-negotiated plea in a sense. I mean, it's a time served offer. But yeah, so yes, it's non-negotiated.
If I may inquire, what portion of the plea is non-negotiated?
Just give me a moment. Okay. So, Your Honor, I reached out to Women on the Rise, and she is going to be accepted she's been evaluated and she has been accepted to their program, where they'll provide her with housing and therapy and any MH treatment or addiction treatment that she may need. I have the confirmation from Trindalyn Browning with Women on the Rise. So I would just ask it be a time served offer. Of course, no further contact with the complaining witness and the stay away from Grady. But the state's requested an 8-week anger management or an MHET. So I would just state that she is going to be getting MH treatment, and she actually wants the release to be a release to Women on the Rise, and she has placement there. She basically told me that she doesn't want to be released unless she can go to Women on the Rise, which is already set up for her. And so I would just ask for the balance of probation to be suspended, since she is going to be going to Women on the Rise, and ask for a release to Women on the Rise instead of the MHET or the 8-week anger management.
The state is agreeable to. Excuse me, Your Honor. State is agreeable to modifying our recommendation that she be released to Women on the Rise. However, we do object to the suspension of probation due to her extensive history, which I'm more than happy to go through with Your Honor.
Okay, so you're agreeable to the release to Women on the Rise, but she's to be on probation while she is working with Women on the Rise.
Correct. And we're
Yeah.
agreeable to changing the 8-week anger management or MHET to the release to Women on the Rise.
Okay, I think that's, Mr. Ty. That way we can guarantee that she stays in Women on the Rise.
Okay, yeah, that's fine. I think she can report to probation while she's with Women on the Rise. I know that they specifically work with women who have been incarcerated, so
Okay,
sure they can
so
help.
is that agreeable to everyone?
Yes.
All right, very good. Anything further before I take the plea?
Yes, Your Honor, I would just like to lay out the recommendation in full.
Yes, go ahead, Ms. Vaughn.
The state's recommendation is to simple battery. Count 1 is 12 months served, 114 days. Credit for time served, 57 days. That's going to be from May 17th, 2024 until today. Balance probated, no further contact with Juliet Alexander. Stay away from Grady Hospital unless it's for medical treatment. Released to Women on the Rise. Count 2 would be time served, 114 days. Credit for time served, 57 days. We would like to sound for Ms. Juliet Alexander and would ask the defense to stipulate to menu of actual basis and identification for the purposes of this plea.
Ms. Alexander is on the call and wishes to address the court. Now is your opportunity. Further, Mr. Ty?
One more thing, Your Honor. The representative from Women on the Rise stated that she needs to be released with 30 days of medication. So if I put that in the bond order, is that something that the jail will do?
I think that it takes time for the jail to get the medication together, Mr. Ty, and that might be up to a week.
Okay.
I already have my medication. It's in there.
Excuse me, not to interrupt. I'm sorry, Mr. Ty, you will have to do an order for that release of medication with the judge, with the information of her proper release. You will have to indicate who she's going to be released to, and what time they're going to pick her up. And you have to have that medication paperwork. Your office do have that kind of form available. If you don't have a copy of it, I guess I could send you an example of it.
Okay, I will. Yes, thank you. If you have an example, that would be helpful. I haven't done that before, so thank you. And I'll include all of that because I understand that she can't go to Women on the Rise until that's prepared.
I already have my medication. It's in my property, Mr. Ty. I wasn't aware that you were unaware.
Oh, okay. Thank you for telling me.
You're welcome.
Okay, anything further before I take the plea?
Nothing further.
Ms. Worthams, it's my understanding that in case 24 CR 004985G, you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Worthams. Good luck to you, ma'am.
I do have a question for you, though. If that's
Mr. Ty?
Mr. Ty?
Yeah, I can come see you if the question is something that we need time to discuss.
I just want to know about my release date. That's all. I didn't.
As soon as everything's ready, Women on the Rise is ready for your release, but it might be 1 or 2 days.
Okay. Okay.
All right, good luck to you, ma'am.
Thank you.
Thank you, Judge Morrow. Quick question.
All right, we'll see you next time.
Quick question, Judge Morrow. Going back to position number 5 for Ms. Brown. Ms. Hoda, your client did want to talk to you. Are you going to come visit her or call her?
I can come there today.
Okay, thank you.
Or I'll call if I can.
Okay, not a problem. Thank you. We're completed here at ACDC. Thank you, Judge Morrow.
Okay. Thank you. We'll see you next time.
Okay, thank you.
Okay, who do we have next?
Your Honor, we're gonna go to Mr. Fisher. He's position 11 and 12, Johnny Fisher. And can we have South Annex call extension 2 22060, 22060. South Annex.
Is South Annex on the line?
Yeah, it says Gibson. It has the sergeant's name there.
Okay,
He's here.
We here, sir.
All right, can you
Okay.
call extension 22060 so the attorney can talk to him? Extension 22060.
22060. Extension
And
220.
Your Honor, this is position 11 and 12, Mr. Fisher.
okay. It's my understanding this is gonna be a plea
Yes,
and
this
an
is
outcross.
a negotiated plea, Your Honor.
Okay,
Yes.
all right. Good morning, Mr. Fisher. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can place your hand down, Mr. Fisher. Thank you. Yes, Ms. McConkey.
Yes, Your Honor. The recommendation is 12 months, served 46 days, credit for time served 23 days, balance suspended, and a stay away from 702 Lakeshore Circle Northeast in Atlanta, which is the Triangle Club. I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
We stipulate, Your Honor.
Anything further, Mr. Ty?
Nothing further.
Mr.
And
Fisher,
of
is my,
course, the FTA I'm sorry, Your Honor. I just wanted to say the FTA will be no frost.
okay, thank you. Mr. Fisher, it's my understanding that in case 23 CR 007618J, you wish to plead guilty to criminal trespass, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Fisher.
Your Honor, I
Yes.
guess we go to Marietta Annex.
Okay, we'll go back to Ms. McLeod.
Is Ms. McLeod ready?
Ms. McLeod, are you with us?
Yes, Your Honor, I am with you.
Okay, and what are we gonna do with Mr. Green?
Mr. Green is going to accept the state's plea offer.
Okay. Let's see, anything further, Ms. Falk?
Nothing from the state, Your Honor.
Ms. McLeod?
Yes, Your Honor, nothing from the defense.
Lewis?
Yeah.
Yes, Mr. Green, you
Yes,
need
I
to
was
speak.
trying to figure out, my release date. How long would it be for they update my release date?
Okay, you'll have to work with Ms. McLeod as far as when your release date will be.
I
The
don't
judge
have Yeah, I don't have no way of contacting her.
You can call me,
The number restricted.
not my phone number. I get calls from the jail every day from my clients.
I don't have it. I don't get nothing right.
Okay, ask the deputy to give you my number.
Okay, Ms. Lewis?
Yes, Judge. Can Ms. Falk clarify this restitution information on position number 4?
I'll be expecting. I know it's in bullshit. That's crazy.
Your Honor.
We're on position 5.
Position 4 is Dexter Freeland.
Oh, I'm sorry.
But I'll be working on that while we're handling this plea.
I'm sorry. I'm jumping
Not a
ahead.
problem.
You have everything you need on Mr. Green's case, Ms. Lewis?
Yeah, I guess I just need to clarify, is he gonna be on probation for two years or just 1 year? It's 2 years.
2
isn't it?
years.
That's what I thought.
Okay, Anything further before I take the plea? If not, Mr. Green, it's my understanding that in case 23 CR 004422G, you wish to plead guilty to battery. In case 24 CR 004393G, you wish to plead guilty to simple battery, 2 counts. In case 24 CR 004419G, you wish to plead guilty to battery. In case 21 CR 003713G, you wish to plead guilty to simple battery. And in case 24 CR 004435G, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Nah.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you...
Yeah, I just wanted to make sure I was gonna get my release date. You say 2-year probation, and what else come with it?
Okay. Let me, Ms. Falk.
Yes, Your Honor.
Would you please go back over the recommendation for Mr. Green?
Yes, Your Honor. The state's recommendation is going to be 36 months with 12 months to serve, credit for time served, 119 days. There is additional requirements of 12 weeks of anger management, that the defendant possess no firearms, have no further contact with Natasha King, Joe Stodgehill, Michael Fleming, Patrice King, and Dawn Harris. And we are also requesting an ADET as part of the probation. That's all for the state.
Okay. And you understand that, Mr. Green? Do you have any additional questions you need to ask of Ms. McLeod?
Nah, I was trying to, that's it.
Okay.
You say I gotta do 60 more days? I mean,
I'll let Ms. McLeod speak to you on that. Okay, you typically get 2 for 1 from the jail, so she can talk with you about how much additional time that would be.
I did discuss that with you, Mr. Green. Remember we had that discussion?
well, how do I supposed to? So I'm not getting 2 for 1 right now.
Yes, you
will get 2 for 1. I believe you are. There's no reason why you shouldn't.
All right. That'll be all.
Okay.
That'll be all.
The state was asking for you to serve 12 months, essentially 365 days. You're getting credit for 119. So with 2 for 1, it would probably be another 61.
All right.
Okay. My last question was, you've been represented by Ms. McLeod. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Mm-hmm.
Yes. Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated now, Mr. Green. Good luck to you, sir.
All right, y'all see.
Judge, he has about an average of 63 more days to serve.
Yeah, about 63, okay.
Mm-hmm.
In medical, I have position number 7, Mr. Clemens, and then someone needs to speak to him. I'm not sure who it is.
Let's see, courtroom 2, who's representing Mr. Clemens, position 7?
I'm representing him, Your Honor, and I haven't spoken with him.
Okay, they're requesting, he is in medical, so how best to achieve that?
Okay, I'll just join in another room and then go in a breakout with him.
Okay, all right, so are you gonna get on your laptop, Ms. Atai?
Yes, Your Honor, I will.
Okay, very good. So as soon as Ms. Atai gets set up, we'll put her into a breakout room with medical.
Your Honor, I have Mr. Freeland, who is also at the Marietta Annex.
Okay, can we go ahead and do Mr. Freeland? What are we going to do with Mr. Freeland today, Ms.
He has two cases on the calendar, Your Honor. He is going to accept the state's offer on one, and on the other one, he wants to enter a not guilty plea.
Okay, so he's got loitering and prowling on position 3 and the theft charges on position 4. Which one is he entering a plea on?
Position 3, Your Honor.
Okay. And you're gonna file a waiver, or should I arraign him in position 4?
I will file a waiver on position 4, Your Honor.
And just to clarify, this is a global recommendation.
Okay.
I think what she's saying, Ms. Falk, is that if they're all not going to be resolved, there might be a different recommendation for position number 3. Is there a different recommendation, Ms. Falk?
Yes, Your Honor, there would be. So we would, if this is not a global recommendation, then we would ask for 90 days credit for time served, 26 days on position number 3.
Okay, well, I'll have to discuss that with my client.
Okay. And just so the court knows, what's the recommendation on the theft charges?
12 months served 90 days, credit for time served 26 days, balance probated in anti-theft course. The restitution remain open for 30 days. Stay away from 861 Hartsford Place Southwest. No further contact with Elaine Holmes. Count 2 would merge with count 1.
Okay. So if we can place Ms. McLeod and Mariana Annex into a breakout room, please. Courtroom 2, anyone else that we can take at the present time, or the attorneys unavailable?
If yeah, no, both of attorneys, everybody in
Okay.
Ms. McLeod or Ms. Atai.
Okay, so you all just, Mr. White, you have any cases that we can
Mr.
take?
Mr. White informed me that he could sit for a pleas if it's
I
Mr.
can accept Ms. Oda's pleas. I'm sure, I assume she wouldn't have any problem with that.
Okay, do you know which ones are please? I'm
Yes,
not,
Your Honor. We have position number 11 and 12, Mr. Fisher. He's a plea. You did okay, so why is this covering? We have position 13, Mr. Gibson. He's a plea.
okay. So let's get Mr. Gibson's the time served plea. Yes, good morning. Just one moment, Ms. McCarthy. Good morning, Mr. Gibson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning.
Good morning. Thank you, sir. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. And your first name is, you can put your hand out. You are Deshay, is that right?
Yeah. Yes.
Okay. All right. Very good. Thank you. Yes, Ms. McCarthy.
Yes, Your Honor. I just wanted to let the defense know that the original plea offer stated no further contact with Maria Manelli, who was the neighbor. The person who owns the residence is Marvin Morrison, so the no further contact would need to apply to him as well. That is the person who owns the resident that Mr. Gibson was in. So is that okay with Mr. Gibson?
Could you repeat the name of the other person?
Yes, Marvin Morrison.
That shouldn't be an issue.
Okay. The state's recommendation is 12 months served, 32 days, credit for time served, 16 days, balance suspended, stay away from the incident location, 2261 La Vista Court, Northeast Atlanta. No further contact with Maria Manelli and Marvin Morrison. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
So stipulated.
Anything further, Mr. White?
Nothing from this end, Judge.
Mr. Gibson, it's my understanding that in case 24 CR 004741F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Ms. Atai and Mr. White. Are you happy with their representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Through the whole term?
Giving up your
No.
right on this charge.
Oh, okay, yeah.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Gibson. Good luck to you, sir.
Thank you, sir.
Thank you, Your Honor.
You're welcome.
Next, we get back in the chair. No, we did not get to be.
Well, we can, is he in? Who is he?
Yeah, he's in here.
Which one?
You sure? It's not guilty.
Yeah, I'm not touching that.
Your Honor, we're gonna just hold off until this holder comes back.
Okay. She had that also Brandon Randolph was a plea. Do you all have him?
No, he might be on the floor.
Okay. All right. Well, you'll just let me know when.
Oh, did we already do him?
Just let me know when we can proceed. We'll be in recess until.
At South Annex? He's gonna be late. Yeah, he's fine.
We have, South Annex on, we can go ahead and move forward with them.
South Annex, yeah.
And we also have my client, Your Honor.
Yes, Ms.
Okay.
McCarthy.
Freeland, yes.
But
So
can we
what-
do, South Annex first so they can get off?
South Annex, so
Okay. Who do we have at the South Annex?
It's position 18, Judge Guardado.
And what are we doing with Mr. Guardado this morning?
In negotiated plea, Judge.
Okay, very good. Can you hear me okay, Mr. Guardado? Can you hear me, sir? Mr. Are you Mr. Guardado?
I'm Tyler Thomas, sir.
Oh, okay.
Here's the guy, hold on.
Always a shooter.
Okay, and Mr. Guardado?
Yeah.
Yes, good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Ms. McConkey?
Yes, Your Honor, the state's recommendation is 12 months served, 34 days, credit for time served, 17 days, balance probated, no further violent contact with Tiffany Guardado, who is the defendant's mother, restitution to the victim in the amount of $240. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
Since we stipulate, just as the probation go, terminate once he pays the restitution.
Okay. If nothing further, Mr. Guardado, it's my understanding that in case 24 CR 004695B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Anyone forced or coerced you to plead guilty?
Yes, sir.
Now listen to my question. Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Guardado, when you pay the $240 in restitution, the probation will terminate. So the sooner you get that paid, the sooner you're not going to be on probation, okay?
Okay, sir.
All right, good luck to you, sir.
Thank you.
Sir, please depart because
Your attorney be back in the.
Okay, can we go back to Marietta Annex or who do we have at the South Annex?
Tyler Thomas, Your Honor.
They're
Mr.
both
Thomas?
Ms. McLeod's, they're both Ms. McLeod's clients, Your Honor.
Oh, okay. So Ms. McCobb, what are we gonna do with Mr. Thomas this morning?
I have not spoken to Mr. Thomas yet, Your Honor.
Okay, so why don't we, I'll give you the opportunity to speak with Mr. Thomas in a breakout room. Let's go back to Marietta Annex. And what are we doing with Mr. Freeland?
Mr. Freeland does want to take the state's offer on the loitering and prowling, and he still wants to plead not guilty to the other charge.
Okay, and he understands that, that there's additional time on that charge.
He does, Your Honor.
Okay. I'm not sure if let me just start at the top with Mr. Freeland. I'm not sure if I have spoken with him. Can you unmute Marietta Annex?
Yes,
Yes, good morning, Mr. Freeland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir, yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir, yes, sir.
Okay, you can place your hand down. Thank you, Mr. Freeland. Ms. Falk?
Yes, Your Honor. State's recommendation on position 3, the loitering and prowling, is 12 months, served 90 days, credit for time served 26 days. That's going to be from July. I have July 5th, 2024 to today. Balance suspended. Stay away from 1770 Richmond Circle in Atlanta, Georgia. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do.
All right, so before I take the plea, Ms. Falk, can you give me the circumstances of this loitering and prowling, please? And I would like to have his history as well.
Yes, Your Honor, I can do both. That's not a problem. So the circumstances regarding this particular case, Your Honor, this incident happened back on, just pull that up, happened on June 30th of 2024. On that date, as you heard, at that location at 1770 Richmond Circle, officers were called out and were observed the defendant at 3:30 a.m. Mr. Michael Hartsfield stated that, Mr. Michael Hartsfield was the defendant's co-defendant. APD Trice was working as security. Both males were seen on the camera looking at ATVs behind building 1101. Due to recent burglaries, Officer Trice stopped the males to inquire about their purposes on the property. They stated their friend was allowing them to have the ATVs, so they were looking at them. They were both sitting inside of a gray Kia Soul. They do not reside at that location, and we're looking at property that doesn't belong to them at approximately 3:30 in the morning, which is an unreasonable time to be at that location, which is not a place of residence, which is not their place of residence. So the issue is that the defendant's history is extensive. The defendant at this time has 45 cycles. The most recent conviction, well, there was a probation revocation in 2022. Let's see, just going back. Some more probation revocations. 2022 burglary. 2022 found guilty of theft by taking, criminal trespass, giving false name out of Fulton County Superior Court 19 SC 171598. There was actually a burglary charge that accompanied that was dismissed. An entering automobile in 2018, along with a criminal trespass and possession of knife or firearm during commission of a felony. The defendant on that case received a 5 years and then 5 years suspended consecutive on that case. Before that, the defendant had a parole violation from 2015, another parole violation from 2014. It looks like that stemmed from a burglary in 2003 out of the Fulton County Superior Court, where he was convicted, and some more probation violations as well as arrests. And there's varied arrests for theft by receiving, burglary, leading all the way up to now. The defendant is currently being held in custody on 24 PI 004826. That's 1, 2, 3 counts of burglary in the first degree. 4 counts of burglary in the first degree, criminal damage to property, theft by taking, possession of tools for commission of a crime. And that is actually 2 different cases, 4286 and 4826 and 4827. And so it's the defendant's history, as well as the fact that he was at a residence at 3:30 in the morning with zero explanation that was reasonable for why he would be scoping out ATVs at that location, as well as his history, which includes burglary, multiple thefts, that the state made that recommendation.
Okay, thank you. That clears things up for me. Anything further, Ms. McLeod?
Nothing further, Your Honor.
Okay. Mr. Freeland, it's my understanding in case 24 CR 004446J, you wish to plead guilty to loitering and prowling. Is that correct? Marietta Annex, you'll have to unmute for me, please.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir, no, sir.
You've been represented by counsel. Are you satisfied with her representation?
Sir, yes, sir.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Sir, yes, sir.
Has anyone forced or coerced you to plead guilty?
Sir, no, sir.
I will accept the plea as negotiated, Mr. Freeland. That's in position number 3. On position number 4, your case will be returned to the division judge, and you'll get notification of your next hearing date, sir.
Thank you, sir.
Anything further on Mr. Freeland this morning?
Yes, can I get a clarification? Is he's to serve 90 days credit for time served, 26 days, Ms. Falk? I can't hear you. Can't hear you. You're on mute.
Yes, Ms. Lewis, that is correct.
Okay, just want to make sure that was correct.
All right. Good luck to you, Mr. Freeland.
Thank you, sir.
All right. So now if we can place Ms. McLeod and
Mr.
South
Thomas?
End into a breakout room, please.
It's going to be Miss McLeod and the Norman Gibson in the breakout room, correct? Okay.
Yes, Ms. Champion. Thank you.
They said you thought they wanted Sergeant Gibson.
Okay.
Let's see. Where's the breakout rooms, Your Honor?
It should pop up on your phone there. There you go. Let's see. We have in medical.
That's Ms. Holder's client. She should be on her way back to the courtroom.
We don't need him. Mr. Lewis.
Hey, Judge, how are you today?
I hope you are as well. Let's see. What case are you here on today?
Position 39, Judge, but I don't know why it's on your calendar. It was on a calendar before where we had filed a waiver of arraignment in advance, and somebody put it on this calendar, and I have no idea why.
I think that they were awaiting a DA transfer. This is position number 39, Ms. Falk. Has that case been transferred?
So, Your Honor, position number 39, Michael Washington. So yes, Your Honor, I have spoken to the DA's office yesterday. They did say they were accepting the case. However, they have not signed the transfer orders and sent them back to me.
Let me make sure I understand this correct. So a preliminary hearing was had on this matter and the court transferred it, but the solicitor's office was waiting for the district attorney's office to transfer it?
No. Go ahead, Ms. Falk.
Yeah. The district attorney's office has the ability and the purview to direct indict any case they see fit. The case was actually if I may finish, Mr. Lewis.
No, just answer my question. Did they indict it?
Let her get through her statement, please, Mr. Lewis. And if you have any questions of her afterwards, once she has completed it, you all can have a conversation, okay? Go ahead, Ms. Falk, I apologize.
Thank you, Your Honor. The case was actually charged originally as an aggravated assault. Judge Brandy Brooks, after
to the court.
Your Honor, if I'm not allowed to speak because Mr. Lewis is going to continue to interrupt me, I just don't see the point. We'll just go ahead and transfer the case, Your Honor.
Okay. So now, Judge, since she has declined to speak further, Judge Brandy Brooks had a preliminary hearing on this matter that the police charged as one thing, and she transferred the case over. And so the question that I'm asking here, since I'm looking at a CR number, is the solicitor's office refusing to prosecute the case that the magistrate who had the preliminary hearing transferred over?
We are not refusing to prosecute the case. We are transferring the case to the DA's office.
So in other words, Judge, since the magistrate has changed this charge and it has not been indicted, and the solicitor's office has decided that they themselves are not prosecuting it, but asking the district attorney's office to prosecute what the magistrate said needed to come down to the state court, what is the court's position on this?
Well, the court's position is that we transfer, that the solicitor's office transfers matters to the DA's office quite regularly. It will come before me for bond hearings sometimes, and once they're transferred, then we just go ahead and I'll issue the bond. But at some point in time, if the DA's office accepts the case, then it'll go to the DA's office. If they don't accept the case, then the solicitor's office will continue to prosecute it here in state court.
Yes, sir. And that's my understanding of the normal procedure as well for a case that begins in the solicitor's office. But in this case, a case was in the district attorney's office. The magistrate holding the preliminary hearing says it did not belong there. And when specifically asked about the case, whether she was going to leave it with the district attorney's office or send it to state court, she specifically ordered it be sent to the state court, and I have the transcript on that, court judge, if you'd like.
Okay, and Your Honor, oh, sorry, Your Honor, I did not mean to interrupt.
You did. So once it gets back to the Superior Court, Mr. Lewis, make your argument there, and if they send it back to state court, then they do. If they accept it, then it'll continue there.
I'm going to take exception to your ruling, Judge, on that. I understand it's the one that you have, and I will take it up before the Chief Judge of the Superior Court. I would ask the court at this point in time, however, to dismiss this case entirely.
Okay, well, and that motion will be denied.
Very good.
Thank you, Your Honor.
Okay.
That concludes my on this matter, sir. May I be excused?
All right. Before y'all guys go, I just need a clarification. So is this case is transferred? Because I don't have a transfer order and I don't see one in the system. And is it just going to be waive arraignment and go to the original judge assignment at this time? That's all I want.
So, Ms. Lewis, the DA's office has agreed to accept this case as a transfer. They just need to sign the transfer orders and send them back to me. The attorney who's handling the transfer orders had court in grand jury in DeKalb County this morning. So he told me he would send these orders this afternoon.
So I just need to hold on.
It's that and a number of other cases. This is a co-defendant case. And so he will be sending me those orders this afternoon. I will send them to you, Ms. Lewis, for Judge Morrow's signature.
So in the meantime, just cases reset further notice.
Yes.
All right, if we're all clear, have a good rest of your day, Mr. Lewis.
Is reset for further notice where?
Well, that's why I was trying to get clarification, Mr. Lewis. They're trying to wait on the order. Normally, I will send this case back to the original judge assignment, which is Judge Porter. And then if I get the order before then, I'll let the litigation manager know for Judge Porter so she can, you needs to be holding on to.
Well, we've been told that Ms. Falk will be in touch if she doesn't get the order today. But it's my understanding from the representation that she expects to get it today, and we should have this all done.
That is
Judge,
correct.
for the court's record, so when we see this 24 CR on a case, that is a case that is not accused, correct?
That is incorrect, Mr. Lewis. The case has been accused by the solicitor's office.
Oh, it has been accused.
That is correct.
Okay, good deal. Judge, for the court's edification, we will file a speedy trial demand today in state court. Thank you.
Okay. All right. Have a good rest of the day.
You as well. Good seeing
Thank
you.
you.
Bye.
Always. Okay, so let's go back to Ms. McLeod, I guess. Where are we, Ms. McLeod?
Yes, Your Honor. With respect to Mr. Thomas, what I see is that the state is recommending that his case be transferred to the DA's office, and I have discussed this with him. However, my client tells me that he needs to bring something to the attention of the court, Your Honor. He tells me that he was assaulted by one of the officers in the jail, and he wants to have that put on the record, and he wants to know how to. I suggested to him that he ought to file a formal complaint, but he was not aware of how that was supposed to be done. And to be honest, I am not sure how it is done either. So he wanted some clarification as to how, because he said he was actually attacked by an officer in the jail and it's on camera, and he wishes to make a formal complaint about that.
Okay, well, I don't know if I have any, I mean, you'll have to advise him, Ms. McLeod. That's out of my purview.
I understand, but he did want it to go on the record that he had been attacked in the jail by an officer.
Okay, so it is on the record, and I suggest that you as his representative move that forward.
Yes,
whatever you choose.
And he also tells me that he went to court and the judge said that the case should be transferred back. So I'm not sure if I understand what is going on, Ms. Falk, because this, it seems to me, involves some kind of alleged battery in the jail. You know,
So,
yes.
Ms. McLeod, if you can just give me the case name again, please.
Oh, yes, it's Tyler Thomas,
Okay,
and I can give you the case number as well.
I have it. It's position 38 on the calendar. So there are several positions on the calendar, just for the court's edification, where there is alleged to have been an attack at the jail. It was charged as aggravated assault. Judge Brooks transferred it down to state court. However, the DA's office recognizes that all of these defendants are currently charged with multiple felonies, and that all of them would be charged under the correct code section, which is unlawful acts in a penal institution. And that's why they accepted the transfer back to the DA's office so they can direct indict this case for all of these co-defendants, which is what I would have been able to say if Mr. Lewis had not kept interrupting me. So thank you, Ms. McLeod, for letting me finish a sentence.
So I was not there when the other case went on, but is that a co-defendant that was just on before me?
Correct. There's like 5 of them, Ms. McLeod, and it's so we couldn't, even if we wanted to go forward, we'd have to have a C3, C4, so on and so forth, because there are multiple co-defendants in this, all alleged to have done this act together.
I see. Yes, well, you know, my client really wants to go to trial. He's indicated to me that he should go to trial on this case because, of course, he tells me he's not guilty at all. So I guess I will waive arraignment for him into this case since it has not yet been transferred.
I'm here, ma'am. I'm here.
Yes. So what the state is saying is that the case is going to be transferred to the DA's office again. But as of today, it has not yet been transferred. So I am going to file a waiver of arraignment into your case and a demand for speedy trial based on what we discussed.
Okay, thank you. Did you tell the judge that I wanted to find out a way to press the charges on the officer?
I did, and the judge was not able to clarify for me. So I will personally.
All they have to do is look at the video.
I understand. I am going to personally work on finding out what is the proper procedure for that so that I can help you with it.
So can I expect you to come here and speak with me?
Yes, but I can't come for at least 2 weeks because I'm going to be out of the country. So when I come back, it will be after the 15th of August.
Yes, ma'am. I want to let you know that I've been incarcerated for 11 years.
You told me.
Wrongfully convicted.
Right, you told me about what happened
at all. And I was basically framed by this officer, Michael Strozier. He had it out for me. When I was jumped on, assaulted, and stabbed by gang members.
Listen, Mr. Thomas, sometimes when we talk, the prosecutors listen, and certain things that we say,
it's okay because it's the truth. I don't mind. This is my only
I
time
know,
to speak.
but my advice to you, I will come to see you, but as I say, it cannot be for at least another 2 weeks because I'm going to be out of the country.
All right.
But when I get back, I will come to the jail, and by that time, I believe I should have the information you need.
Yes, I want to be certain that I want to move forward, and I want him to review the cameras, and I want to press charges on this officer. He assaulted me, he dry tased me, and he's been doing it. It's a lot. I can't get internal affairs in, and he's framing me. He had it out for me. I didn't do 11 years in the prison and then pre-trial detainee, and to come to be.
I will come to see you, Mr. Thomas, when I get back.
Because I'm not letting up. They're not letting up. I'm not letting up. I'm gonna fight with every drop of blood in me. I want those cameras reviewed, and I want internal affairs involved in this assault. And the doors weren't operable.
Ms. McLeod is going to be with you, sir.
Yes, I will come to see you, but as I said, I cannot come for the next 2 weeks.
Sorry for my frustration, Your Honor. It's been 11 years, and I haven't had due process, and I've been just taking away from my family.
I will come and see you, Mr. Thomas.
Okay, he's going to be working with you.
Thank you, Your Honor. It's been a hard road. June was a bad month for me, so thank you so much.
Yes, sir. Yes, sir.
No worries.
All right, let's see. Ms. McLeod, do you have any cases this morning?
One more, Your Honor, Mr. Wilson.
You have 2 more, Ms. McLeod. Mr. Green, on the add-on? No.
I thought we dealt with Mr. Green already.
I'm not sure because he's on
There's
the
another Green on the add-on counter, Noah Green.
Yeah, that's position number 9.
Oh, okay. I have not spoken with Mr. Noah Green.
Okay, we can go to Mr. Wilson.
Yes.
Can we do position number 7, the one in medical waiting?
We can go on that.
Okay, so where are we now?
With Mr. Wilson.
What calendar is Mr. Wilson on? Oh, here we go. What are we doing with Mr. Wilson today, Ms. McLeod?
We are trying to revisit the issue of bond for Mr. Wilson, Your Honor.
And is Mr. Wilson, is this him in courtroom 2?
Yes, Your Honor.
Okay. Good morning, Mr. Wilson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see. May I get his history, please? Ms. Tyson, are you with me?
Yes. One moment, Your Honor. I'm trying to pull his history up right now.
Okay. Do we have the current bond?
I wasn't able to pull it, Your Honor. It wouldn't show it to me. It was hidden. But he tells me that it's like a
bond if you like to know.
It's a good bond of some sort. I think he said $2,000 or $3,000.
It's a $1,500 good bond that you issue out on July the 15th of 2024 SCA calendar. It's $500 on each count.
And whenever you're ready, Ms. Tyson.
I'm having issues getting it open, Your Honor. One moment.
Can you tell me the facts, Ms. Falk?
You're muted.
Didn't realize I was muted. Thank you. So yes, and I can give you the history as well, Your Honor, if you want me to go over the history briefly.
Thank you.
So this defendant is a multi-state offender. He has a 2012 simple assault domestic violence 3rd degree out of Homewood Police Department in, it looks like Homewood, Alabama. The defendant also has I'm just counting the cycles, Your Honor. It appears to be 36 cycles with Georgia, kind of going backwards so that we don't have to go all the way back. The defendant's most recent arrest was this arrest. He also has a March 14th, 2023 arrest for aggravated assault out of Fulton County, a January 8th, 2023 arrest out of Atlanta for criminal damage to property in the second degree. The defendant was convicted on 23 SC 189434, which is a battery family violence first offense. He received 5 years probation as well as a cruelty to children in the first degree. Prior to that, the defendant had an arrest for simple assault family violence from May 4th of 2022. Defendant, it looks like a time expired restriction on a simple battery willful obstruction under 19 CR 007404A out of Fulton County. And I can just look into that to see what the conviction was, if any. Probation violation from 2018, November 2nd of 2018 out of Fulton County, and failure to appear going back to 2018, a probation violation in 2017. And I think that's kind of a good stopping point for us. As far as his 2019 case in Fulton County, Your Honor, the defendant, this case was dead docketed in July 22nd of 2021. But as I stated, the defendant does have a 23 SC case that he was convicted of for family violence battery in the first offense of family violence battery, as well as cruelty to children in the third degree, where he received 5 years probation on that case. As far as this incident is concerned, and I just do want to go back and see, and he also has a 23 SC 187265 conviction for aggravated assault, possession of firearm during commission of a crime, possession of firearm by a convicted felon. The family violence, the cruelty to children in the third degree, that incident involved, and I just want to double check, that incident involved Judea Walker, and that was the victim in that incident. As far as this case, Your Honor, this incident happened in July 12th of 2024, involving Miss Destiny Walker. The defendant grabbed her while she was in the vehicle, kicked her vehicle aggressively while she was in her vehicle and spat on her purposefully. She also threw the child's clothing at her window in a form of intimidation. As I have stated, this defendant has multiple convictions, as well as, and two of the convictions, the 23 SC 187265 and 23 SC 189434 convictions, both involve Miss Destiny Wilson. As a part of those convictions, he was ordered to have no further violent contact with Miss Destiny Wilson, as well as to take family violence intervention. And so there is a history here, Your Honor, which I believe is what led Your Honor to give a $1,500 surety bond on this simple assault, simple battery, and disorderly conduct case, due to the fact that he has had 2 prior convictions with the same victim, Miss Destiny Wilson. At this time, we would like to sound for Miss Destiny Wilson.
Ms. Wilson's on the line and wishes to address the court. Now is your opportunity. Ms. McLeod.
Yes, Your Honor. I did speak briefly with Miss Wilson, and I thought she was going to appear, Your Honor, but I have not seen her. My client is not in a position to pay bond, and that is the biggest issue. He does share 3 minor children with Miss Walker. They are 9 years old, 6 years old, and I believe 3 years old. So they have been together for more than 10 years, he tells me, Your Honor. And my understanding, based on what he tells me, is that he was the sole breadwinner for the children, and it's been a huge hardship for these children because he can't get out. And even though his bond is relatively low, he's still sitting in jail simply because there are no funds to post bond for him. So essentially, until he goes to trial, if he doesn't get a signature bond, he's just going to be sitting in jail. And that's the reason why we were asking the court to consider modifying his bond to a signature bond.
Your Honor, I will also state that this incident happened in the presence of the 11-year-old juvenile TW, which is one of his children, as well as Miss Nanette Frederick, the mother. So there were more than one witness to this incident. And again, the defendant has 2 prior felony convictions, both involving Miss Destiny Walker.
And I believe that I remember this from the SEA calendar, and I believe that one of my inquiries was, had he done any of the family violence intervention that he had been ordered to do, and I don't believe that that he had. And I believe that because of the circumstances is why I gave him the relatively low $1,500 good bond. I'm not inclined to modify it at this point in time.
Okay. Thank you.
Good luck to you, Mr. Wilson. Who do we have next?
Mr. Wilson, you can always call me later if you have any questions.
So what are we doing with this case? This case is reset to the original judge, or?
Yes, his case will be returned to the division judge, and he'll get notification of his next hearing date.
Thank you, Your Honor. I do need to speak to Mr. Green, Mr. Noah Green.
Where is he located?
He's in courtroom 2. He just.
Okay. Can you call courtroom 2, Ms. McLeod?
Yes, or they can call me. It's usually easier because sometimes when I call, it gets transferred somewhere else.
You can call Ms. McLeod.
Okay.
Okay.
This courtroom.
The
Green.
Who can we take now?
We have position number 22. I'm sorry, Ms. Blunt. Let me just do position 22 real quick. I'll explain later.
42?
Yes, position number 22.
22?
What? That's it right here.
Mr. Terrell's.
Okay.
That's Ms. Carroll's.
Okay.
So let's see, who's representing Mr. Durrells?
I am, Judge.
Okay, this is going to be a plea.
It is.
All right. Good morning, Mr. Durrells. I'm Judge Eric Morrow. This is
I
the
don't
state.
identify as Mr. It's Miss Violet.
Mr. Terrell?
I'm a Black trans woman.
Okay. Well, thank you, sir.
Listen
Yes.
to the judge.
Yes. Well, thank you, ma'am, for clarifying for me. Ms. Durrells, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard
Yes,
by
Your
video?
Honor.
All right, very good. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. I didn't realize I was going to give a testimony.
Well, you might be answering yes or no questions for me later, okay?
Okay, yes, sir. Yes, Your
Okay.
Honor. I agree. It'll be
Okay.
honest and truthful.
Oh, well, thank you so much. You can place your hand down. Thank you. Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation for count 1, the criminal trespass, is 12 months, concurrent with count 2, stay away from Grady Hospital except for medical necessity. The state's recommendation for count 2, the PI, is 12 months, serve 45 days, credit for time served 15 days, balance probated, and SDET, and of course, stay away from Grady except for medical necessity. I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
Stipulate, Judge, and just ask that his probation terminate upon completion of the requirements.
Mr. Durrells, it's my understanding that in case 24 CR 004793A, you wish to plead guilty to criminal trespass and a second misdemeanor offense. Is that correct?
Your Honor, I really wish to plead nolo contendere.
Had you discussed that with him, Mr.
He
White?
never made it an option. I'm not admitting guilt to such a thing. I wish to plead nolo contendere.
Okay, let's see. Ms. McConkey,
Yes, Your Honor.
does the state have?
And I wish to be released
objection?
to a mental hospital because I'm actively suicidal for being abused in jail.
Ms. Jarrells does have a PI conviction from 2023.
There is no conviction. There's nothing in 2023. It is
Let me
pending. You are
triple check
lying.
that. Let me triple check that.
Be that as it may, he's still allowed to enter the NOLO, Judge.
Yeah, I'm trying to ascertain if that's the case, Mr. White. And Ms. Tyson?
Yes, Your Honor.
Do you have Ms. Jarrell's history for me?
Yeah. You have 28 arrest cycles beginning in 2007. Last arrest is in Clayton County, April 14th of 2024 for misdemeanor criminal trespass and criminal damage to property in the second degree. It appears that case is pending. There's no disposition listed on the GCIC. There's also an arrest out of Athens, Clark County, July 29th of 2023 for willful obstruction and violation of family violence order. There's no disposition listed for that case on the GCIC. And there is a previous PI arrest from July 17th of 2023 out of Athens, Clark County. There is no disposition listed on that case. So that may be the case Ms. McConkey was referring to. There's just no disposition. Okay, yeah, there's no disposition listed on the GCIC. There's a FTA from 2019 and 2021 felony conviction out of Clayton County for aggravated assault, willful obstruction of law enforcement officer. The disposition date on that case is October 2019.
Okay, thank you.
Yep, that's within the last 10 years, Your Honor.
Okay, thank you, Ms. Tyson. Now, Ms. McConkey, could you tell me what the allegations are here?
Yes, 1 moment. Let me get back to my notes. Okay. So this incident occurred July 15th, 2024. Officers were dispatched to Grady Hospital and met with the security supervisor who advised that the defendant, Violet Jarrell, had received treatment at the hospital and had been told several times to leave, to which she refused. She was escorted off the property, but returned and then removed her clothing and sat on top of a Clayton County Patrol vehicle and exposed herself. The state, given her history, is objecting to a NOLO at this time.
I'm going to allow her to plead NOLO to these charges with the recommendation of the state. Okay, so Ms. Jarrells, I'm going to allow you to plead NOLO to criminal trespass and
Thank you, Your Honor.
Okay, so it's my understanding that in case 24 CR 004793A, you wish to plead NOLO to criminal trespass and one other misdemeanor offense. Is that correct?
Yes, Your Honor, and I want to be released directly to a mental hospital because I'm actively suicidal in jail from being abused here.
Okay, well, that's not a part of the terms.
The rest of the time will be on probation.
That's not a part of the terms of this plea, Ms. Jarrells.
So what do I need to
That's
do,
not
Your
something
Honor?
you can arrange.
Say it, Mr. White.
I don't believe that's anything that we can actually facilitate it anyway. I mean,
Right.
Is mental health treatment diversion court an option to ensure that I get the help I need? to prevent issues like this in the future. I have a mental health diagnosis and I'm disabled. And I'm a college student at UGA. I can't go through this.
Okay, Mr. White, I'm gonna need to give you some more time to speak with her.
Judge, we went
I'll
over all
accept
this
the plea, but I just can't. I take the plea gladly, but I don't understand. They're trying to crucify me for something that I went to Grady Hospital and was abused and never treated. I have a history with Grady and they were abusive to me and I overdosed in the ER and they refused me treatment. I'm suing Grady behind this. And I will appeal I can't, I just can't. I want to go, I need to go get help. I am mentally unwell in jail being abused by the officers and the inmates. I want to kill myself right now.
All right, Judge, given this, I think we have to withdraw the guilty plea. I mean, he understands. We talked about this yesterday, and I'm sorry, she understands everything within the plea.
Can we,
I was asked yesterday about releasing him to mental hospital, and we can't facilitate that. I mean, there is,
can we at least have a social worker visit with him?
Yes.
To address some of these concerns?
Absolutely. And
okay.
The escalation that I did not know of any of this until just now. So.
No, I understand, Mr. White. I just want to, I want to do what's best by her.
Thank you, Ron.
And I think that's what's best at this point in time is that we have a social worker visit. We see if we can assist in whatever ways that we're able to. Now, I'm not back on this calendar. I mean, until a week from now. So I'm happy to reset it for a week. And from I'll make a note that we'll have a social worker visit to address some of her concerns within that time. She wouldn't have been getting out anyway.
Exactly.
I'll also make a note, and you make a note, Mr. White, also, if you would, for me, that I agreed to accept a no-lo if I'm just in remembering, and we'll see what services we can provide her.
Okay.
Thank you, Judge.
All right.
Thank you, Your Honor. Have a great day, Your Honor.
All right, I'll see you next week, ma'am.
Can we please do position number 7 now? Thank you.
Okay.
What is a week from today?
Where is position number 7? Excuse me.
Medical.
Okay, Ms. Atai.
Yes, Your Honor.
Go ahead.
This is a not guilty plea and a bond argument.
Okay, and you're going to file a waiver?
Yes.
Yeah, it's fine.
All right. Good morning, Mr. Clemens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
All right, thank you, sir. Let's see. Can I get the current bond and the history, please?
The current bond is a $1,000 good bond. No further contact with Devontae Page. Stay away from the incident location. And that bond was set July 17th, 2024 by Judge Law.
Okay. And what are the facts?
The defendant is accused of punching the victim, Devontae Page, in the face 2 times. The victim did sustain swelling and bruises to his face. The defendant did admit to hitting the victim, but he stated that it was in self-defense because the victim had a bottle in his hand.
Okay. And the history, Ms. Tyson?
Just wait.
We have 10 arrest cycles out of the state of Georgia beginning in 2008. Last arrest was in DeKalb County, August 3rd of 2023. That was for a failure to appear. It appears there may be a pending forgery in the 4th degree out of Spalding County. That arrest date was June 23rd of 2023. Note states that the case was transferred to state court. No other information was provided after that. Does have a felony conviction out of Henry County for forgery in the 3rd degree from June 22nd of 2023. There's a misdemeanor conviction from out of DeKalb County for battery, family violence, first offense from August 14th of 2023. A violation of probation 2019 is a, let's see, and there is a most recent felony conviction is in from Fulton County for, let's see, looks like armed robbery that was amended to robbery and false imprisonment in 2011. One moment here. And it looks like there is a hold or active warrant out of McDonough for a probation violation. That warrant was signed May 29th of 2024. Nothing to add, Your Honor.
Given the defendant's history, of course, the state believes that the $1,000 good bond is more than appropriate as it stands.
Thank you, Ms. McCarthy. Ms. Atai?
Yes, Your Honor. In the last 10 years, I didn't hear other than one violent offense. Other than that, it's forgery, and the robbery, Your Honor, is from 2011. That's very remote. And Your Honor, he does deny the allegations as stated in the warrant. The stay away address listed here is 3129, and this is the incident location, Candlewood Drive. And the complaining witness doesn't live there. He was invited to a party. This is the home of Angelo Gamble, and he is on the line, and he, of course, is the homeowner and was there during the incident and has told me that the complaining witness, Devontae Page, did wield a large alcohol bottle and was attacking my client with that. And as he told the officers who responded, he was acting in self-defense. And so because of that and the fact that he's been in jail for 14 days, I would ask for a signature bond through pretrial services, even if it has to be at level 4, just to give him the opportunity to, present his defenses without having to sit in jail any longer. And he does have a hold in Henry County, so he would be transferred to Henry County once he's released from Fulton County. And I would like to ask the court to sound for Angelo Gamble.
Mr. Gamble, I see you there. If you would like to address the court, now is your opportunity to do so.
I would also ask the court to sound from Mr. Devontae Page.
And if Mr. Devontae Page is on the line and wishes to address the court, now is your opportunity to do so. Ms. Atai?
Yes, Your Honor.
So what I'm gonna release him to the hold. I don't want to litigate this here today. It'll be a $10,000, if you'll just make note, it will be a $10,000 signature bond through pretrial level 3. 1 day anger awareness, no further contact with Devontae Page, stay away from the Candlewood Drive address, no drugs, alcohol, or weapons. Okay, so if you'll make those modifications, I'll release him to the hold.
Thank you, Your Honor.
All right, good luck to
Your
you,
Honor,
Mr.
does he have any contact information or anything? Because a lot of times it's hard for supervision to catch up with them when they're being released to a hold somewhere.
Does he have can you get his contact information
Yes.
to pretrial?
I'll get his contact information today, and I'll send it to pretrial services.
Thank you.
Good luck, Mr. Clemens. Okay, where can we go next?
We can go back to Ms. McLeod's client, Mr. Green, Noah Green. That's position 9 on the add-on calendar.
Okay, and what are we doing with Mr. Green today?
This is going to be a negotiated plea, Your Honor.
Okay, very good. Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? And is that a yes?
Yes, Your Honor.
Okay, thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can place your hand down. Thank you. Yes, Ms. Falk.
Yes, Your Honor. On position 9, on the add-on calendar, the state's recommendation is 12 months, serve 120 days, credit for time served 21 days from July 5th, 2024 until today. Balance probated, no further contact with Iceland Cunningham, family violence intervention program, 40 hours of community service, as well as no firearms. We would like to sound from Ms. Cunningham at this time, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Ms. Cunningham is on the line and wishes to address the court. Now is your opportunity to do so. Mr. Cloud,
Yes, Your Honor, we stipulate.
anything further before I take the plea?
No, Your Honor.
Mr. Green, it's my understanding that in case 24 CR 004435G, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Freeland. Sir, Mr. Green, good luck to you.
Thank you, Your Honor. And I believe that concludes my business before the court today. May I be excused?
Yes, will I see you this afternoon?
I do not know. I've not been asked it, Your Honor.
Okay, well, if not, enjoy your vacation. We'll see you when you get back.
Thank you, Your Honor.
Who do we have next?
We can go to position number 6, Mr. Roderick Brown.
What are we doing with Mr. Brown this morning?
Sorry. Oh, Your Honor, I'm sorry. This is it's a non-negotiated plea.
Okay. And given that it's time served, I take it that there's an issue with anger management or the community service?
Yes, again, Your Honor, but Gar Hogan is on the line, and he is the PAD representative who has been working with Mr. Brown for 2 years now. He does have placement where at a recovery center once he's released from jail. So I think I would ask for him to be released to PAD. Of course, you can. And then with PAD going to a recovery center, and that all just, he can't do 12 weeks of anger management and community service while he's trying to get the necessary services at an inpatient facility that he needs.
What inpatient facility will he be going to?
Your Honor, if I may address the court.
Yes, good morning, Mr.
Good morning to all. To add to counsel's presentation, I have worked with Roderick. I know him well. Good morning, Roderick. It's been a while.
How you doing?
Roderick was actually stepped down in that program, and that means he was assigned a single case manager rather than my team. But I do know Roderick for a long time now. I don't know the details of this case. I know able counsel on both sides will present those things. 2 things that the court needs to know. First of all, his present case manager, Gene Walls, was, I believe, a day or so away from a firm placement in Ascensa Recovery Center. That was the former St. Jude's. Because Gene returns from vacation Thursday of this week, I have not been able to confirm that if Roderick's released tomorrow or today, or exactly that he can go to Ascensa. So however your honor and counsel can work it out, it is our intention, and I believe it's all done, but I just can't confirm it. But that will be the facility. The other thing to say is that anger management and these other things, all very appropriate within the court's power and counsel's argument. But Roderick, may I briefly have your permission to speak to some of the history there?
Yes, sir.
Okay, given HIPAA considerations, thank you, Roderick. Knowing Roderick for a long time, about a year or maybe more, my guess, my supposition is that whatever facts that may have led the state to be seeking anger management are almost certainly related to substance abuse. I told counsel when we began to talk about this that he's a really good man with a really big substance abuse problem. And I think counsel's work and the state's agreement to accept substance abuse treatment and Roderick's agreement for some weeks now, as I understand it, are the things that will resolve the state's concerns about not repeating some kind of angry behavior. Again, I'm not informed about the specific things. So it is my belief, Your Honor, that if you all can work out the logistics and that starting Thursday morning, Gene Walls can confirm this and get him into Ascensa, but I believe the concerns about the behavior and possible need for anger management will be subsumed within a really good treatment program at Ascensa.
Can you spell the first name of the recovery center?
ASCENSA.
And it's an inpatient treatment facility?
Yes, and it's not one that gives you 7 days. It's I think once they go in and assess, they determine how long, but it's a pretty long treatment program. I know from one of my own participants that it was 6 months or more. It's again, all concerned must know that this kind of a treatment program can't hold you there. No one's locked inside. However, assuming Roderick's continued desire for recovery, this is a great program that will stay with him a long time. And, Roderick willing will really address this serious grip of drugs that he's had for some time. He deserves a chance to get the addiction set aside and then address his responsibilities to the state and the community.
Thank you, Mr. Hogan. We appreciate it. Yes, Ms. McConkey.
Yes, Your Honor. This incident occurred June 29th, 2024 at the Lindenburg MARTA station. The defendant is accused of pepper spraying Miss Elizabeth Sanchez. Ms. Sanchez stated that she heard the defendant verbally assaulting an Asian male with racial insults, and she stood up to defend the male when the defendant pepper sprayed her. Both her eyes were red and they were swollen. A second victim, Ms. Tamika Bumpus, stated that she was also hit with pepper spray on the side of her face, and it also hit her left arm and her hair. The defendant has 47 arrest cycles. I'm sure Preshaw could give more details into that, but I do see that he has a 2022 arrest for simple assault. The state's recommendation is 12 months served, 64 days credit for time served, 32 days, balance probated, no further contact with the victims in this case, stay away from all MARTA facilities, 12 weeks anger management, 40 hours community service, no firearms. For count 2, of course, would run concurrent with count 1, and it was no further contact with the second victim, Ms. Tamika Bumpus. And I would ask the court to sound for both victims, Ms. Elizabeth Sanchez and Ms. Tamika Bumpus.
If Ms. Sanchez or Ms. Bumpus are on the line and wish to address the court, now is your opportunity to do so. Mr. Ty.
Yes, Your Honor. So, of course, it's a time-served sentence, but as you heard from Mr. Hogan, the PAD representative, he will be entering into a treatment program, and it's a long-term inpatient program. So I would just ask, instead of the 12 weeks of anger management and 40 hours of community service, and even reporting to probation, that he have the opportunity to focus on his treatment at Ascensa. So if we need to put that in the bond order, or sorry, not the bond order, I don't,
It's a condition of probation.
yeah, a condition of probation that he completes the programming at Ascensa and would be transferred there from, or released to PAD and then transferred to Ascensa.
If the court would permit me to add briefly,
Okay,
just as Ms. Atai is saying, the state's concerns are of course reasonable. But my concern, as a guy who's mostly concerned about Rod and his recovery, and of course the people in the public, is that he be allowed to complete the treatment, and then if anger management is Your Honor's choice, that be able to happen afterwards. In other words, as Ms. Atai is saying, if these things, if he were to have to try to do both at the same time, it seems almost certain that he will violate, not necessarily because of his choice. That's all.
And the state is okay with making Ascensa a condition of his probation, and we are okay with eliminating the anger management, but we do still think it's appropriate for him to complete the community service. And that can happen after his completion of Ascensa.
And Judge, as any good recovery program, it's almost certain that he would receive some training and work on anger management. And I appreciate counsel's consideration of his recovery path.
okay, Ms. Atai, with the modification by the state, would he agree to do the 40 hours of community service with all the rest of the
Yeah, I believe
No.
that he, sorry.
No, I was just saying that the courts is inclined, sentence would be 12 months to serve 64 days, credit for time served 32 days, balance probated with the no further contact of Ms. Sanchez and the no further contact with Ms. Bumpus. He's to be released to PAD to be transferred to a center, recovery center, and he is to remain in as an inpatient treatment until he is released by Ascensa.
Your Honor, if all parties would agree, if this release could happen on Friday, then Mr. Walls.
We have to get there. I have to make sure everybody's gonna agree, then we'll figure out.
So Your Honor, you
Along
would
with-
not be willing to suspend the probation while he's at the recovery center?
Well, he can still be on probation. He can report by phone. So just to make sure that, that he remains there. So I don't want him, and Mr. Hogan's told me that it's a voluntary program. And if he voluntarily leaves and he's not released, then he's going to be in violation of his probation. Okay, so although it's voluntary, if he decides to leave, then the probation will know about it, and the probation is may be terminated or revoked. Excuse me.
Okay, can we
Okay.
waive probation fees? He's not gonna have any income while he's in a recovery center.
I agree with you. So in this limited case, I don't normally do this, but because of his special circumstance, I will waive the fees while he's on probation to help him get and stay on his feet, and so that he does not violate the probation. But he's also going to have to do the 40 hours of community service. Okay.
Okay,
All right. And since I'm waiving the fees, Ms. Atai, he's going to be on probation the entire time. Okay. Ms. McConkey, does the state have any objection to any of the court sentence?
No objection, Your Honor.
Okay, so and Ms. Atai, do you have any objection to the court sentence?
no objection, Your Honor.
Okay, so that makes it a negotiated in that manner. Okay.
Okay.
Now, Mr. Hogan, I know that you've had some concerns about when he won't be released until you all arrange for him to be picked up. So he'll be at the jail until you make arrangements, I guess through Mr. Ty, for him to be released to PAD and then to be taken to Asensa.
Thanks, Your Honor. On behalf of my client who will be just getting back from vacation, we appreciate it and we will move quickly to get to Ms. Atai to make those arrangements. Thanks.
Okay, very good. Anything further before I take the plea?
Nothing further to state.
Okay. And I'm sorry, Mr. Brown, I've been talking about you without addressing you. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes. Can I say
Thank you.
something? If that's the problem, I just keep my mouth. No worry.
Well, you have a right to remain silent. Anything you say can be used against you, Mr. Brown. If you want to speak with Ms. Atai before we go forward, I'm happy to
I
let
want
you.
to get community service while I'm in the program. I can do that. If there's any kind of way I can do that while I'm in the program.
You can arrange that with the program.
Okay.
If they allow you to do it, that's fine with the court, okay?
Can I say something, Mr. Gardner? Mr. Gardner, could you come get me as soon as possible, please?
I'm sorry, didn't hear that, Ron.
Please come and get me as soon as possible, please.
Gene returns Thursday morning. I'm sure he will call your lawyer by the middle of the day. I know the paperwork's underway, and we won't forget you, Ron.
Okay, that's the tempo. Thank you.
Okay, can you raise your right hand for me, Mr. Brown? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. It's my understanding, Mr. Brown, that in case 24 CR 004256F, you wish to plead guilty to battery and simple battery in a public transit vehicle or station. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Brown. And I think that we've gone through all of the conditions. Ms. Lewis, did you have a question?
I do. Is there an address for this recovery center for probation? We'll know where he'll be located at.
I'll have to provide that to Ms. Atai and ask her to forward that to you.
Okay, and I guess Mr. Ty, you will send out the release order. And you say he want him to be released on Friday, you say, sir, Mr. Hogan?
I would say Friday morning at the earliest. Mr. Walls, who is going to make the placement in at Asensa, gets back from a vacation Thursday morning. What I will do is ask Mr. Walls to contact Ms. Atai immediately to let probation know what the timing of all of this is going to be. And again, I think we all want the same thing, which is to get him into treatment as soon as possible.
Okay, so I guess Mr. Ty, I think I sent you a couple of samples of order release. So you just have to get who he's going to be released to, the time and the date. So the jail will know how to properly process him out. Because without that, me putting that information on the counter, they're going to want that order to be specific and they're not going to release them until it's clear.
Okay, thank you, Ms. Lewis.
You're welcome.
All right, good luck to you, Mr. Brown.
All right, thank
you.
Who do we have next?
Position number 14, Gibson. Medical.
Okay. This is going to, who's representing Mr. Gibson?
That's me, Your Honor.
Okay, would you like me to arraign him or are you going to file a waiver?
We can just arraign him, Judge, and we'll waive formal reading.
Okay. Good morning, Mr. Gibson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Mr. Gibson, you've been charged in case 24 CR 003047H with obstruction or hindering persons making an emergency telephone call, and simple battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. White, that you're waiving formal reading of the accusation.
That's correct, Judge.
How do you plead, Mr. Gibson? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Good luck to you.
Thank you.
Who do we have next?
We can go to position number 8, Mr. Cofield, Curtis Cofield. Yep.
It does also, we still have the DV counter, and we still have some attendance counter for the DV at 11 o'clock.
Yes, who's representing Mr. Cofield?
I am, Your Honor.
Okay, are you gonna file a waiver? Or do you need for me to arraign him?
I'll file a waiver.
Okay, anything further this morning?
Nothing further. This is a not guilty plea.
Okay, Mr. Cofield, your case will be returned to the division judge, and you'll get notification of your next hearing date, sir.
Okay,
All right, good luck to you.
okay, thanks a lot. Okay, good.
Excuse me?
Yes, who's speaking?
Yes, this is Michelle Figaro McIntosh, the victim.
Yes, Ms. McIntosh. Mr. Cofield has pled not guilty to these charges. This case is going to be reset, returned to the division judge. Ms. McCockey, if you can have someone get in touch with Ms. McIntosh to explain to her the procedure from here on out, if the victim advocate wouldn't mind speaking with her.
Yes, of course, Your Honor.
Okay.
You will reach out.
Thank you.
All right. Have a good day, ma'am.
Okay.
Who do we have next?
We're waiting for either jail court's iPhone or medical.
Okay, while we're doing that, given that it's going on noon and we haven't addressed the 11 o'clock DV bench warrant calendar, can we take the, let me see who we have here on that calendar. Position number 1, Ramsey Allen. Yes, I see you there, Mr. Allen. Has someone had an opportunity to speak with Mr. Allen? Mr. Ty, are you handling the DV bench warrant calendar?
Yes. For
Okay, have
Mr.
you,
Allen and Mr. Chief to you.
okay, Mr. Allen is with us. Mr. Chitio. I don't see him. Oh, yeah, I do see him here. And Stephen McGoy.
I
Mr.
believe
McGoy.
Stephen
McGoy is my case judge.
private attorney.
Okay, and this is Miss Kim's. Is that you, Miss Kim?
Yes, Judge. Good morning.
Good. Yes, good morning. Let me go ahead and take Miss Kim's case, Miss McGoy. I take it that he missed a court date, Miss Falk?
Yes, Your Honor, he did. Just pulling that court date up. It appears that he missed the 4/29/2024 calendar before Judge Richardson. It was an FTA. The bond was then forfeited, and a rule nisi was issued on May 2nd of 2024.
Okay. Ms. Kim, why did he miss that court date?
We just got the notice. I think with the Postal Service, they're so far behind. I just got a notice for a case in May that's completed. So I think the fault is through the Postal Service that he got the notice late in the mail.
Okay. Mr. McGoy, I normally set aside a bench warrant on one occasion. If you'll please stay in touch with the I'm not sure where we're getting that feedback from. That might be you, Mr. Allen. You might need to mute for me. Thank you, sir. You'll need to stay in touch with it's still someone is getting feedback. stay in touch with the court, give them a call to make sure that you don't have any court dates. I understand the mail situation. Ms. Kim, if you will prepare that set aside, we'll get it signed and entered. My normal course is that I allow people I'll set it aside on one occasion.
Judge, who would I send this proposed order to?
Send it to Ms. Lewis, Ms. Katrina Lewis.
Trina Lewis. I will prepare it. Thank you, Judge. May we be excused?
Yes, have a good day. Thank you.
You as well.
Let's
Check
go.
your chat. She hung up.
Let's-
I'll try to check her chat. I have sent my email in there. But I know how to get in touch with her, Judge.
Okay, thank you. Let's go to Mr. Allen. Good morning, Mr. Allen. Ms. Falk, I take it that Mr. Allen also missed the court date?
Yes. Yes, Your Honor. The court date that Mr. Allen missed was on May 30th of 2024 before Judge Dixon, a plea and arraignment calendar. The bond was then forfeited and a Rule Nisi was issued June 7th of 2024. The case also looks like it appeared on the bond forfeiture judgment calendar, at which point a warrant was issued on June 21st of 2024.
Okay. Mr. Ty. Courtroom 2 is on mute.
Yes, Your Honor, he did not receive any notice. And I would like to ask you to set aside the FTA for the bench warrant, Your Honor.
Okay, did he, do you have where notice was sent, Ms. Falk?
Yes, Your Honor, just going back to that case. Let me see.
592 Woodall Road.
Did you get a notice, Mr. Allen, or did you just get it late?
No, sir. I was informed by my pretrial officer that I missed my court date due to me changing locations in February, and I updated with him my information, phone number, address. I didn't realize I needed to contact the court as well. So
Okay,
that's why.
all right, yes, you always have to contact the clerk's office and make sure that you change the address with the clerk's office. It's not pretrial's obligation to change your address. So I just want to make sure that we have your correct address in the system. So that because I normally will set aside a bench warrant one time, but if it happens again, then it won't be set aside the next time, okay?
Yes, sir.
All right, and you're telling me that you've already changed your address with the clerk's office?
Yes, sir. When I reported last Monday to set this Zoom meeting up, I changed it in the system there.
Okay.
So they have the correct
Your Honor,
address now.
Can you,
Yes.
just to verify, Mr. Allen, can you give your address currently?
7727 Nolan Trail, Snellville.
Okay, that is the address that we have on the updated notice. I just wanted to make sure there were
All right,
no excuses next time that we had the correct address.
thank you. So, Mr. Ty, if you will prepare that set aside, we'll set it aside on this occasion. All right, Mr. Allen, if you have any other movements, make sure to contact the court first thing, okay?
Yes, Your Honor.
Okay, let me just go ahead and finish up with this calendar. I'm sorry, sir, I'm probably not going to pronounce your name right, Mr. Chitikyo.
Oh, you're fine. My name is Tanaka.
Tanaka, yes, sir.
Good afternoon.
Yes, good afternoon. Ms. Falk, I take it that Mr. Tanaka missed the court date?
Yes, Your Honor. The defendant missed a court date on July 2nd, 2024 before Judge Roth at a plea and arraignment calendar. He failed to appear.
Mr. Ty?
Yes, Your Honor. He states to me that he reports to pretrial every month, the first Tuesday of every month. And on the Tuesday, I believe that he missed court, he reported a pretrial and they said, oh, you missed your court date. And he had no idea about it. He didn't have a change of address even, but he didn't receive any notice at all. And by the time he reported a pretrial on that Tuesday, he had missed the court date. He didn't know about it.
Do you have where that was sent, Ms. Falk?
I'm sorry, was it said he did not have a change of address?
Apparently not, but I want to make sure that it
Okay,
was
so
sent.
I have two different addresses, Your Honor. I have a 8090 Adair Lane, Atlanta, Georgia. That's where his original notice was sent. When he came in on July 23rd, the address is 5907 Spring Creek Lane. So it's completely different addresses.
So that's the I think the Adair Lane address is like the apartment number, is the apartment street number, and then that address has 5907 as the apartment number, but 5907 Spring Creek Lane is still the address. So it's the same. Those are two different addresses that should come to the same exact space, but I usually do have trouble with receiving mail because of that reason. I think it's 8090 Adair Lane, and then in the part that you that usually asks for the apartment number, that's when you would fill in 5907, which is the apartment number. But I usually just use 5907 Spring Creek Lane. But when I did go to the clerk's office, she I guess she put in the right one, or I'm not sure exactly how it goes. She also gave me the number to the litigation manager, and I was able to talk to her just to make sure I am able to get my mail in the future.
Okay, Mr. Tanaka, where would you give me an address where you think that you can get proper mail? So I know there's some confusion, but where do you normally get your mail so that we can make sure we have that?
5907 Spring Creek Lane, Sandy Springs, Georgia 30350.
Is there an apartment number associated with that, sir?
Yeah, that's what. So it's two different addresses. So if you put in the 8090 Adair Lane, that's when you would insert the apartment number. But the 5907 is just the full 5907 Spring Creek Lane is just the full address. You don't insert the apartment number because the 5907 part of the address would be my unit number, I guess.
So you're saying not to insert the unit number?
No.
He's saying send it to 5907 Spring Creek Lane. Is that what you're saying, Mr. Tanaka?
Correct.
Okay. So you need to check to make sure, given that there's some confusion, you need to check on a regular basis with the court to make sure that you don't have a court date. So I'm going to set it aside on this one occasion. But if we have any confusion the next time, it won't be set aside. You understand?
Yes, sir.
I'm sorry to interrupt, Judge, but I'm validating his address and checking it. When I typed in 5907 Spring Creek Lane, it came up as 809 ADIR Lane, apartment 5907, Sandy Spring, Georgia 30350. That's the way it came up in the because we have a way of validating the address through the postal service. And when I put that address that you just told me put it in, it converted to 809 ADIR Lane, apartment 5907.
Yeah, that's fine.
Right.
That's what I was trying to say earlier. That works as well. It should come to the same place.
I think it's supposed to have been that way too, because the way I'm looking at it from last time, they had Atlanta, Georgia on there instead of Sandy Springs. So your correct address, which I have right now, is 8090 ADIR Lane, apartment 5907, Sandy Springs, Georgia 30350. That's what your address, your notice and stuff will be going to. That's correct?
Yes,
Okay.
ma'am.
Okay, it's correct.
Your Honor, I apologize to interrupt. Am I excused?
Yes, Mr. Allen, you're excused. Have a good rest of your day, sir.
Thank you. You do the same.
Thank you. And Mr. Tanaka, you're excused as well. Have a good rest of your day.
Thank you.
All right, who do we have next?
We have positions 43 through 47, Mr. West.
Okay.
Good morning, Your Honor.
Yes, good morning, Mr. West. Let's see. Who's representing Mr. West? Mr. White?
Yes, Your Honor.
Okay, you need for me to arraign him?
That's correct, Judge. Of course, we'll waive formal reading.
Okay. Good morning again, Mr. West. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Mr. West. You can put your hand down. Thank you. You've been charged in case 21 CR 0035668C with public drunk, simple battery, and criminal trespass. In case 22 CR 007858C with willful obstruction of law enforcement officers and possession of marijuana less than an ounce. And in case 24 CR 004732C with simple battery, family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. You waive formal reading of the accusation, Mr. White.
We do, Judge.
How do you plead, Mr. West? Guilty or not guilty?
I can plead no content.
Mr. West, if I have just a minute, Judge. Mr. West, Mr. West, we talked yesterday. You did not want to accept the plea offers, and we were going and explained today that we would be entering a not guilty plea. Have you changed your mind?
Yeah, I had second thoughts about it. I talked to my family and we had second thoughts about it.
Okay, Judge, can we reset his case then?
Yes, it looks like why don't we just reset it for a week? So it comes back to me instead of going to someone on Thursday, okay?
Thank you.
All right, I'm gonna reset your case a week, so I'll see you next week, Mr. West, okay?
Yes, sir, thank you.
All right,
All right,
thank you.
can you tell me when next week?
Same time, whatever, from 9 till we're done.
All right, thank you.
Okay.
All right, next we have positions, number 30 and 31, Mr. Randolph.
And this is going to be a negotiated plea.
That's correct, Judge.
Okay, good morning, Mr. Randolph. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Yes, Ms. Falk.
Yes, Your Honor. On position 30, the defendant has charged with theft by shoplifting. State's recommendation is 12 months, serve 40 days, credit for time served 20 days. From July 11th, 2024 to today, balance probated, stay away from Publix located at 2900 Peachtree Road, anti-theft course, 40 hours community service, and a $500 fine. On position 31, the state is entering a null pros. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We stipulate to, and we just ask that the probation terminate once he completes all of his requirements.
Okay. Mr. Randolph, it's my understanding that in case 23 CR 005732J, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Randolph. When you complete the terms, the probation will terminate.
Sorry, Your Honor, if I may, sorry to interrupt. The state does object to termination of probation based on the defendant's history and prior convictions for theft by shoplifting.
Okay. Well, given what the sentence is, I will have it terminate once he completes the terms. Good luck to you, Mr. Randolph.
Okay, so wait, what was she saying about the second count? Y'all was breaking up. I didn't hear what y'all was saying.
Oh, that's gonna be null pros, though. That's gonna be dismissed.
Oh, it's up here?
What?
Yes, sir.
Yeah.
Okay, all right, thank you.
Okay.
All right, here we go. Next we have, position number 25, Mr. Lewis.
Okay, and you'd like for me to arraign him?
Please, Judge.
Good morning, good afternoon, Mr. Lewis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you. Mr. Lewis, you've been charged in case 24 CR 004696E with theft by deception and criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. White?
Yes, Your Honor.
How do you plead, Mr. Lewis? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Thank you, Your Honor.
That's all we have on this one. I gotta go across the hall and grab one more person.
Okay.
Okay.
Your Honor, the previous case, what position was that?
That was position 25, I believe.
25. Corey Lewis. Okay.
So we don't waste any time. I know we have maybe 3 more people to do. Would anyone be opposed to going over the calendar?
Of course not, Judge. Right here.
Oh, it looks like we have someone else. Let's see. Who do we have in? Oh, do we have anyone in medical?
No, I had one person I was trying to get before you all, position 40 and 42, Mr. Michael Wesley. He's refusing to come. He don't want to speak to anyone. I've been back there trying to get him up for about 15, 20 minutes.
Judge, that was a not guilty. I was just gonna have you arraign him, but I'll just go ahead and forward.
You file a waiver?
A waiver.
Okay.
I did speak with him yesterday, but I'm not
41.
shocked by this development.
Okay.
Okay.
All right, so 41 and 42 will be returned to the division judge. Waivers being filed, Ms. Lewis.
All right. All right, ready to go over the calendar. The probation revocation calendar, position number 1 and 2 are reinstated. Position number 3 is commute to time served. Going over the DV counter, all the cases were FTA were set aside and the cases are reset further notice, and we did verify everybody's address. Starting with the add-on counter for today, position number 1, John Carter, is his position 1 and 2 are reset for trial further notice. Position number 3, which is Freeland, that was a plea. Position number 4 for Freeland was waive arraignment, reset for trial further notice. Position 5, which consists of Mr. Green cases, 5, 6, and 7, and 8 on the add-on were all pleas. Position number 9, which is Noah Green, that case was a plea.
Ms. Lewis, what was for number 4, Dexter Freeland?
That one is going to be waive arraignment, reset for trial further notice.
Okay, thank you.
We're going to the original calendar now. Position number 1, don't have an answer. That's Ashley, Mr. Ashley, position 1 and 2. Is there an announcement?
We're waiting on him.
Oh,
be
that's the
brought.
one we waiting on? Okay. Holding for 1 and 2. Position number 3 was a plea. Position number 4, defendant was waiver of arraignment, not guilty, and is amended bond order for a $5,000 SOB through pretrial level 1. Position number 5 was not guilty, waiver arraignment, we set for trial further notice. Position number 6 was a plea. Position number 7, defendant waiver arraignment, not guilty, we set for trial further notice, amended bond order to a $10,000 SOB through pretrial level 3. Position number 8, waiver arraignment, not guilty, we set for trial further notice. Position number 9 was a non-negotiated plea. Position number 10 is null pros. Position number 11 was a plea. Position number 12 is null pros. Position number 13 was a plea. Position number 14, defendant was arraigned, not guilty, we set for trial further notice. Position 15 and 16, defendant was released, we set further notice. Position 17 was a plea. Position number 18 was a plea. Position number 19 was a plea. Position 20 was null pros. Position 21 was a plea. Position 22, we set for SAP August the 6th. Position 23, I didn't get an answer.
We're holding.
We're holding, okay. Position 24, I see there's supposed to be a null pros enter, even though she was released. Are we still submitting the null pros? Ms. Falk? Hello? What did she say?
We will submit the null pros
Okay,
today.
for 24, for Brenda Jordan? Okay, thank you. Position 25, defendant was arraigned, not guilty. We set for trial further notice. Position 26, are we holding?
Yes, I have it. We haven't addressed yet.
Okay. Position 27 and 28 and 29, defendant waiver arraignment, not guilty. We set for trial further notice. Position 30 was a plea. Position 31 was null pros. Position 32, 33, 34, defendant waiver arraignment, not guilty. We set for trial further notice. Position 35, 36, 37 is reset further notice. Defendant has been released. Position 38, I guess we're holding. That's Tyler Thomas.
That was a DA transfer.
Wasn't that Attorney Krails?
No, that's 39.
I'm talking about 38. Mr. Thomas.
It says DA.
It's transferred and it's conflict as well, so.
Okay. I hear what y'all saying, but I just want to make it clear, when I put this information to the system and put it on its calendar to the jail going to be asking for these transfer orders, and I have not seen none come through, or if I'm going to actually get one.
That's up to the state.
So I just received the first transfer order, Michael Washington. So they are coming in. The DA is sending them to me as we speak. So I am sending you the Michael Washington transfer right now, Miss Lewis, for the judge's signature.
got that.
The
What
rest
about
will
Mr.
come as the DA's office signs them and submits them. But again, I have every assurance from them we will have all of the orders done today.
So Mr. Thomas is going to be a transfer to the DA.
Yes,
Okay.
ma'am.
Okay. I just want to make sure, because I'm marking these, and they're going to be asking me for these orders.
No, and I understand, and I'm sending you now the Watley order. So that
Okay.
has also just now been signed by the DA's office.
Okay.
So as I get them, I am forwarding them directly to you.
Okay. Okay, position number 39, also the same announcement for 38. Is transferred to the DA's office. Position number 40. We're still holding. I have that as a.
Yes.
I have position 40 right here, if y'all want to do it.
You don't want to take 40 now and pause the calendar?
Okay, this is going to be a plea.
Yes, Your Honor.
Good morning, Mr. Weldon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Can you repeat that, sir?
Yes, we're doing this by video. Is that okay with you?
Yeah.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is time served on count 1, 30 days, served 15 days. Count 2, 12 months, served 30 days, credit for time served 15 days from July 16th, 2024. Balance suspended, stay away from all MARTA stations until July 6th, 2025 per the MARTA suspension. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Right.
Of course, we stipulate, Judge, and Mr. Weldon is aware of his suspension now until July of next year. We just ask you to accept the pleas negotiated.
Mr. Weldon, it's my understanding that in case 24 CR 004807J, you wish to plead guilty to fair evasion and criminal trespass. Is that correct?
Oh, yes, yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
No, sir.
Okay, listen to my question. You understand you have a right to a trial by jury, but because you're pleading guilty, you're giving up that right. You understand?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, I'll accept the plea as negotiated, Mr. Weldon. Good luck to you, sir.
All right, thank you.
You're welcome. Okay, we'll continue with the calendar until jail courts comes back.
Okay. That was position number 40 who took a plea. Position 41, waiver arraignment, we set for trial for further notice. Position 42, same announcement, waiver arraignment, we set for trial for the notice. Position 43, 44, 45, 46, 47. All is going to be reset for the SAP counter for August the 6th. Position 48, waiver arraignment, we set for trial for the notice. Also, same
Actually, Ms. Lewis, position 48, you have
Oh,
received
sorry.
the transfer
Well, that
order.
was Mr. McLeod had said at the time, so I'm sorry.
Right.
So that's gonna be reset to the transfer to the DA's office. 48 and 49? No, just 48, right?
No, 49 as well. I've sent all the transfer orders as I was receiving them just now during the plea.
Okay, so 49. Okay.
Oh, 40,
49
excuse me,
things, so I thought
49 is
49 was
not,
waiver arraignment. You said
that
for
is
trial
correct.
for the notice.
49 is not a transfer. That is correct.
Okay. Okay. Let's go back. Make sure we all on the same page. Position 48 is going to be transferred to the DA's office. That's the charge with the battery. Position 49, which has the traffic violation charges, is all going is waiver arraignment, we set for trial for the notice. Okay. Position 50, that's going to be transferred to the DA's office, correct? Okay.
That is correct. We sent the order on July 15th. We received the order and submitted it for signature.
Okay. Position 51, we set for trial for the notice. 52 was a plea. And that should take care of the calendar until we get the other ones to appear.
Okay, a couple of things. 49, was that taken care of before court today? Because you said waive,
Your Honor,
I don't have that.
That was Miss McLeod's client, and I thought she said she was filing a waiver of arraignment.
I know she addressed 48. I don't remember her addressing 49.
Right.
Oh, okay, well, I thought she was good when y'all was talking about him in his cases. I thought y'all was talking about both cases.
I thought I heard her say that she would be sending a waiver on the case too.
Okay, all right, if that's the case.
Not
Okay.
100% of that, but.
I mean, I can
Okay.
always call her to clarify that to see if she's gonna waive the arraignment, but that's what I thought she said she was gonna do.
Okay, and Ms. Lewis, I think I misspoke on position 23. I think that's also a DA transfer.
23, Jones, okay. Yeah, that's, I know we were holding, so that's good, that's a DA transfer. So they'll
Yes.
bring him out.
Okay, so it looks like,
We're still holding on 1 and 2.
I'm 26.
Mhm.
We ever get
26. Okay,
26.
Your Honor, can we reset 26 to Thursday? If there's room? No, but about Tuesday.
The 6 will be more appropriate, yeah.
Okay, so can we reset that one to August 6th?
okay, so Marcel Norman, position 26, August 6th, reset.
Yes.
Okay,
He also has another case.
And that's what I think that it's not on the.
It's not, no, it's not on the counter, but I will
charge.
make sure I add it on for
Oh, okay.
August the 6th.
Yeah, because
It's,
I think it's in the next column.
Yeah,
The other case. Okay,
yeah, I'll make sure both cases are on there.
thank you.
Uh-huh.
This one.
Is that only one that we're the announcement on, besides 1 and 2?
I think so. I think 1 and 2 is left. What are we gonna do with Jericho Ashley today? Have you all spoken with?
I haven't been able to speak with him. I got here early this morning. I think that they said he's refusing to speak, but I would reset him also to, if it can't be this Thursday, then Tuesday.
Yeah.
He's been set up fine.
He's been reset many times.
Oh.
I don't see jail court's iPhone on anymore, so I think that will take care of everyone if we reset Mr. Ashley.
Yeah, he's been reset 1, 2, 3. This is his 4th reset. So we still
Has
gonna
this-
reset him? Go ahead, I'm sorry.
No. I apologize. I didn't mean to interrupt. Has this been referred maybe for Mr. Bartels to take a look at, PD Bartels?
Yes, our social worker's here and she stated that that he was, but maybe he was found competent. It's not a competency issue.
Okay.
I think we should reset him one last time. And I'll do everything I can to see him here.
Okay, so till next Tuesday.
Yes, please.
And do you have any? Have all the deputies left? Courtroom?
There are no deputies in the courtroom, Judge.
Okay, I just wanted to make sure that if they're trying to get him, that they know that we've reset him. That will conclude the calendar for today. So.
I'll find Norris.
Yeah, we'll let them.
Okay, all right, thank you. All right, let's see, anything further this morning or this afternoon now?
No, Judge,
Okay.
I got everything. I will get you those orders as soon as I get them to me. And I think, Mrs. Asante, I think I gave you examples of,
Yes,
How
and I'll
to-
send everything all
Yeah,
together in
I
one.
appreciate that. And Ms. Falk, I'll be waiting for you.
Thank you.
Okay.
And I think I got all the null process. Thank you.
And,
Yes, Ms. Vaughn.
oh, I was just gonna ask, Ms. Lewis, do you mind putting your number in the chat so I can give you a call after court?
Oh, sure. Hold on.
Thank you.
Okay, I'll see you all next Tuesday.
Thanks.
Thank you. Y'all have a good rest of your day.
Oh, I know, right? Oh.
What was that? Sometimes he should not try to use his personality to try to get control of the court. It doesn't have to.
Well, I told her, I said, you got to spoil the practice. If I don't get your way.
Then you wanna say, I want, you have to assume in isolation.